Good morning and welcome. Today we begin a two-day public hearing to consider issues related to railroad revenue adequacy and issues regarding how the board calculates the railroad industry's cost of equity capital. When I started this proceeding, it was in recognition of a change in the railroad industry. As recently as the 1970s, the industry was in dire financial straits, plagued by bankruptcy and deteriorating physical assets. In the intervening decades, however, the rail industry has rebounded tremendously, due in significant part to regulatory changes designed to foster a return to revenue adequacy. Today, we are in the midst of a rail renaissance. The rail industry carries a vast range of commodities, from agricultural products and energy products to manufacturing inputs and retail goods, traffic that amounts to more than 1.7 billion tons of freight a year. Now that the industry is both financially healthier and restructured with far fewer large railroads, I believe the board should continue the process I began of examining its core policies to ensure that they fit today's modern rail industry and meet the goals that Congress laid out for the agency. The board's re-examination of its rail economic regulatory policies does not necessarily mean that significant changes to these policies are in order. Assessing the effects of any proposed regulatory action in this proceeding is a consideration of the utmost importance. Recognizing that, my goal is to make sure the board's policies reflect thoughtful, balanced decision-making that takes into account a modernized rail industry and sound economic principles. I would like to thank my fellow board members, Vice Chairman Ann Begeman and Commissioner Deb Miller, for supporting me in carrying out this important evaluation. I would also like to thank the parties for their thoughtful comments and for the extensive economic analysis many of them provided. The board's decision-making benefits greatly when stakeholders contribute their views in a proceeding like this one. Before we begin, let me just take a few minutes to review a few procedural points about today's hearing. We want to hear today and tomorrow from every party that has filed a notice of intent. To allow that to happen, we will have to ask the parties to stick as closely as possible to the time that has been allotted. We recognize that that is not always going to allow you to say everything you want to, but we want to make sure that there is an opportunity for everyone to speak. We will keep the record open for 14 days after the conclusion of this hearing to allow for the filing of additional written comments. You will have a light before you at the front of the room. 1 minute before your allotted time is expired, a yellow light will appear. When you see the red light, your time is expired. Please conclude your thoughts at that point. If you are scheduled to speak, please make sure that you check in with the clerk at the front of the room. I have also been asked to remind speakers to please speak clearly into the microphone. In addition, the public should be aware that a video archive of the entire hearing will be placed on the STB website within a few days of the close of the hearing. In the likely event that we have a fire alarm or other event requiring evacuation, please proceed in an orderly fashion out of the double doors at the back of the hearing room and out of the building through the front entrance. Specific instructions have been posted at the back of the hearing room for assembly and notification of return, if any, to the hearing room following any evacuation. Also, a note regarding slide presentations. If you haven't done so, please send an electronic copy or 2 hard copies to the board's Office of Proceedings within the next 2 days. Contact information is available from the clerk. Finally, if you have not done so already, please turn your cell phones off. Also, we will be taking a lunch break. We haven't set the exact time, but it'll probably be after the third panel, but we'll see how the panels go as we go forward. With that, I will turn it over now to Vice Chairman Begeman.
Thank you, Dan. And I want to join in many of your comments. I certainly agree with much of what you said. I strongly supported initiating this proceeding back in 2013. I've been working on these issues for most of my career, not specifically railroad revenue adequacy, but that issue really did come to the forefront when I was on the Senate Commerce Committee when we worked on the 2009 Commerce Bill, and there was a provision that talked about the need for the board to do what we are doing now. So I think it's long overdue. this is a very complex, complicated subject matter, and I really appreciate all of the different filings and the fact that so many are here today and will be here tomorrow to offer their views. Mostly, I want to hear what you have to say, and I'm trying to stay somewhat open-minded, although I do have strong opinions. I'm not looking to turn the clock back on the industry. The industry's success is key to shippers' success. But I'm very interested in everyone's comments, and I really thank you, Dan, for chairing the hearing, and I also thank you, Deb, for establishing this hearing when you were acting chairman and announcing it. So thank you. I think we're all eager to continue this process.
Well, good morning, and I too want to welcome you here and apologize to those of you from out of town for bringing you to D.C. in July, although I must say you're lucky to be here today and not earlier in the week. I kind of wanted to play hooky today. It was such a beautiful morning as compared to what we have had. And I also want to say a thank you to staff, and to note for those of you who've been in this room many times, since the last hearing we have new television screens, which are bigger. Hopefully that'll make it easier for you all to see. We have a new sound system, and we're hoping that will improve the quality of the audio. And we have Wi-Fi in the room, and hopefully for many of you that will make these hearings easier for you to keep up with your daytime job and being in here. And staff had to scramble to get everything done and hooked up, and I'm really pleased to see it all done today. I was thinking this morning, and I think we could sort of say, today's hearing brought to you by the Staggers Act. 35 years ago, I don't know that anybody could have imagined that we would need to worry about the issue of revenue adequacy. Hard to imagine that we could have gotten here. So it's a true testament to the Staggers Act that 35 years later, we even have a need for having this hearing at all. Certainly, no one, having read summaries of everyone's comments, is asking us to turn the clock back or to fully regulate railroads in any way. And certainly that's not a goal of anyone on the board that I am aware of. We've made remarkable progress, and we certainly want to keep that going. And I think it's a good thing to remind everyone and to remind ourselves that when we're talking about the regulation the STB does, we're talking about 5% of the car loadings currently, based on today's information, are available for our regulatory efforts. So it's not the entire freight movement on the system that we're even talking about today, but a much smaller slice of that pie. I do think, though, that with the improved financial health of the railroad industry, it's time for the board to give meaning to the concept of revenue adequacy, and in particular to consider what relief, if any relief, should be afforded to shippers once a carrier has become revenue adequate. I have noted several times in other venues that I consider the issue of revenue adequacy to be part of the issue, I don't consider revenue adequacy to be separate from other issues that are before the board, such as the Knit League proposal for reciprocal switching, or the grain rate hearing that we had last month. And it is my belief that what we should do at the conclusion of this hearing as a next step is to propose changes to the existing regulatory framework based on all of those issues that are before the board. Now, whether that means a drastic rewrite and overhaul of our regulatory framework, a few tweaks, or perhaps concluding we need to stay with the status quo, I certainly couldn't say today. I simply think it's important that we bring these proceedings to a close as soon as possible. With that, I'm eager to hear the testimony and get started with today's hearing. Thank you all for being here.
Thank you very much, Vice Chairman and Commissioner. Now we'll have the first panel come up. I did want to note before we start that we do have Wi-Fi access now, and I believe that it's on one of the sheets that you grabbed when you came in. So we heard some mild complaints over the years that you can't look at your phones. So hopefully we've remedied that. So I urge you to try it out, see how it works. This will be the first time we used it. Okay, now we'll hear from the first panel, Western Coal Traffic League, and you have 60 minutes.
Thank you. Chairman Elliott, Vice Chairman Begeman, Commissioner Miller. I represent the Western Coal Traffic League, Consumers Energy Company, and South Mississippi Electric Power Association. They're known collectively as the Allied Shippers. With me today are Dr. John Hennigan of Micra Consulting, former director of the ICC's Office of Economics, and Dr. Harvey Levine, independent consultant and former vice president for economics and finance at the Association of American Railroads. With our allotted time today, I would like to briefly summarize the positions of the Allied Shippers on the two main issues raised by the board in this proceeding, which are set out in detail in our comments, and respond specifically to the 5 questions posed in the board's May 8th notice. Then among the 3 of us, we hope to answer any additional questions that the board may have. The first topic on which the board invited comments in this case is whether changes should be made to the methodology used to make annual industry-wide determinations of revenue adequacy under the governing statute. The Allied Shippers' position is that the STB should revise its approach so that its findings catch up with the consistent assessments of the financial and investment communities and accurately reflect the major railroads' obvious financial health, both currently and prospectively. In his testimony in both phases of this proceeding, Dr. Levine demonstrated that by any reasonable measure, all of the major U.S. railroads have been revenue adequate as defined in Section 10704A for a number of years, and confidently can be expected to remain so for the foreseeable future. He detailed the metrics supporting this conclusion in his testimony, and I will not repeat them all here. But when one looks at such indicators as increased dividends, robust CapEx plans combined with share repurchase programs, lower operating ratios, higher returns on equity, and stronger stock prices, it is clear that the carriers have broad access to necessary capital and are earning revenues that meet the statutory criteria. Dr. Levine also debunked the rather extraordinary claim advanced by Union Pacific that it and the other carriers actually face major capital shortfalls, showing that such a position can only be sustained by manipulating the test specifically to produce that answer. To bring the board's annual determinations more into line with the proven financial realities and the statutory criteria, the Allied Shippers proposed that the board consider expanding its analytical model from exclusive reliance on the mathematical return on investment cost of capital formula to a multiple indicator approach, as was advocated by former ICC Commissioners Clapp and Gilliam in the proceeding where the return on investment cost of capital test was adopted. We suggest that the board consider utilizing the 6 indicators discussed by Dr. Levine: market-to-book ratio, debt-to-capital ratio, operating ratio, return on shareholder equity, cash flow return, and dividend payout rate. The general recommended approach would be to develop a composite index of these indicators and use it as a check on the results of the return on investment cost of capital test. Specific procedures and data sources should be developed through the notice and comment process so that all interested parties and stakeholders can have input and the board can have the benefit of their evidence and viewpoints. One thing that the board should not do is entertain the railroad's arguments for adoption of a replacement cost approach to measuring a carrier's investment base for revenue adequacy purposes. The practical obstacles to such an approach have been documented and acknowledged for the past 30 years by the board, its predecessor, the Railroad Accounting Principles Board, and railroad economic experts who are not in the employ of the railroads. And as Dr. Levine and Dr. Hennigan testified, those obstacles remain today. Tellingly, with one exception, the railroads and their witnesses in this proceeding offer no solutions to the proven flaws in the replacement cost approach. They simply argue that the board should stop using revenue adequacy for any regulatory purpose until solutions to the problems with using replacement costs are found, the same solutions which have defied discovery for 30 years. Effectively, they propose to write revenue adequacy out of the rail regulatory scheme altogether, now that it can no longer be used as a propaganda tool. As we said in our comments, this is an argument for regulatory nullification, not progress. The one exception, CSXT, suggests that the railroad could solve, or the board could solve the replacement cost problem by performing a full standalone cost analysis on each railroad every 10 years and index the results for the years in between. CSX does not explain how the board would perform these analyses fairly without engaging in the multi-year, multi-million-dollar proceedings that currently are required in order to determine standalone cost for only a portion of a single railroad system. They do not address who would pay for these proceedings, how the board could craft accurate indices to adjust the values every year, or how their approach is materially different from the one previously considered and rejected by the board in Ex parte 679. All the railroads also ignore the need for a revision of the cost of capital methodology to accompany any replacement cost-based investment calculation in order to avoid double counting inflation. As the RAPB previously found, the lack of a solution to this problem alone makes serious consideration of a replacement cost approach futile. The second major issue raised by the board concerns implementation of the revenue adequacy constraint under the coal rate guidelines. It bears repeating that this is not a proceeding to consider whether the board should adopt a revenue adequacy constraint. That was done in 1985, when revenue adequacy was acknowledged by the ICC to be the first logical constraint on a railroad's pricing on captive traffic. That finding was affirmed by the Third Circuit, applied by the ICC in a number of cases arising in the wake of the adoption of the coal rate guidelines, and remains a key element of the law of rail regulation today. The purpose of this proceeding is to affirm the methodology to implement the central principle of the revenue adequacy constraint as explained by the ICC, which is that once a railroad is revenue adequate, further differential pricing on market-dominant traffic cannot be justified. As we explained in our comments, the Allied shippers submit that prior precedent establishes the basic constraint that should be applied. As was held in CF Industries versus Coke Pipeline, a revenue-adequate carrier should not be permitted to impose further real rate increases on a captive shipper's traffic. The constraint should be available for invocation by any shipper that brings a complaint against a rate increase and is able to establish board jurisdiction through a showing of market dominance. Once the shipper shows market dominance and that the defendant is revenue adequate, any new rate increase imposed by that carrier on that shipper's traffic should be deemed unreasonable and unlawful, subject to two limited exceptions. First, a revenue adequate railroad should be permitted to adjust captive rates for actual cost inflation, as measured by the RCAF adjusted for productivity. This will prevent the constraint from threatening the carrier's revenue adequate status and will give effect to the ICC's admonitions in the guidelines that carriers should not be subject to arbitrary rate freezes and should not be required to adjust their rates constantly to exactly maintain an equilibrium of revenue adequacy. Second, and also consistent with the guidelines, a carrier should be permitted to adjust rates on particular traffic beyond actual inflation if it can show a specific need for higher revenues, specific harm that would result if it could not recover them from the shipper in question, and an inability to raise the needed revenue from any other source. The burden of proof to establish that a rate increase in excess of actual inflation should be allowed would be on the carrier, just as the burden of proof under the standalone cost test falls on the shipper. Consistent with established board precedent in this area, revenue adequacy for purposes of the guidelines should be determined on a case-by-case basis, and a shipper invoking the revenue adequacy constraint should be permitted to present any evidence that it considers relevant in order to demonstrate that the railroad meets the criteria of Section 10704. However, in recognition of the long-term nature of the revenue adequacy concept, and in order to avoid delay in the threshold determination, Allied Shippers proposed that the board also adopt a presumption that a railroad whose 4-year average return on investment is equal to or greater than the average of the industry cost of capital, properly determined, or the multi-factor analysis threshold over the same period, is revenue adequate for purposes of the guidelines. The 4-year approach is consistent with the board's 3 benchmark methodology and reflects a reasonable business cycle. As we did in our comments, we emphasized that the constraint we are proposing would apply only to individual movements following a showing of market dominance in a complaint proceeding, and would operate only to limit the carrier's ability to increase a captive shipper's rate once it has satisfied the revenue adequacy test. In its May 8th notice, the board also posed 5 specific questions with respect to the revenue adequacy issues raised in this proceeding, and I would like to turn to those now. Question 1 referenced the guidelines observation that revenue adequacy should be measured over time, and asked what an appropriate measuring period would be. As we stated in our comments, and as the board and its predecessor have confirmed, whether a railroad is revenue adequate for purposes of the coal rate guidelines first constraint should be determined on a case-by-case basis. However, we endorse a 4-year rolling average as a sound basis for a presumption of revenue adequacy. 4 years is consistent with the time period reflected in the 3 benchmark methodology, and it was specifically endorsed by then Commissioner Clapp in Ex parte number 393. It is consistent with the admonition in the guidelines that railroads should not have to adjust their rates annually to precisely match the revenue adequacy line, and it is reasonable in light of our primary remedy, that rate increases beyond actual inflation would not be permitted on captive traffic. The shipper would bear the burden of persuasion both as to market dominance and revenue adequacy, and if the complaint is successful, the railroad only has to cancel a specific rate increase or set of increases on that shipper's traffic. Given the practicality and limited reach of our proposed remedy, a 4-year measuring period for purposes of establishing a presumption of revenue adequacy is appropriate. Some of the railroads in this proceeding have criticized the use of various financial metrics to measure revenue adequacy on grounds that they are not sufficiently long-term in their outlook. A 4-year analytical period addresses this alleged problem and smooths out bumps or anomalous results that might be observed in 1 or 2 indicators. The railroads also have advocated the use of exceedingly long measurement periods, such as the life of the assets employed in the rail business. But this is simply another argument against any meaningful rate constraint based on revenue adequacy. A remedy that requires the analysis of data over a 20 or 30-year period and can't be employed until a record spanning a period of similar length is established is no remedy at all. Question 2 asks whether a revenue-adequate railroad should be required to pre-justify future rate increases, and whether such a requirement would be consistent with the governing statute and previous case law. Allied Shippers' position is that the revenue adequacy constraint must be applied consistent with the existing statute and in the context of the coal rate guidelines. Section 11701 limits the board's authority to regulate rates to complaint proceedings. An established precedent clearly places the burden of persuasion on complainants, both with respect to jurisdiction and the merits of rate relief. Under our proposal, therefore, a captive shipper would have the burden of demonstrating both market dominance and the revenue adequacy of the defendant before invoking the presumption that an increase in its rate beyond actual inflation is unreasonable. The railroad then would have the ability to rebut this presumption by showing either that its proposed increase did not exceed RCAFA inflation or that it meets the specific revenue need criteria set out in the guidelines. That need criteria comes straight from the guidelines, which were approved by the Third Circuit. And the remedy that we propose does not require departure either from the statute or prior precedent. The board employs rebuttable presumptions in a variety of contexts, including the limit price rule that was adopted recently for market dominance determinations. Similarly, it allows for the possibility of individual rate adjustments to the revenue to variable cost ratios identified in the 3 benchmark methodology. Question 3 asks whether a revenue-adequate railroad's ability to continue to differentially price should be limited to all captive shippers or just a subset of the most captive, and if the latter, how the board can best determine those most likely to be the subjects of market power exploitation. Allied shippers would caution against adopting a revenue adequacy constraint that is susceptible to overcomplication or could slide into a SAC-type analysis. Under Section 10701C, a railroad is permitted to control its own pricing unless it enjoys market dominance, in which case the rates on the market-dominant traffic must be reasonable. Neither the statute nor the board's precedents contemplate degrees of market dominance. And as we have noted, rate relief from the board can only be secured upon complaint, which itself is a differentiating process. The statutory scheme clearly contemplates that regulation is to be applied on an individual shipper basis. Allied Shippers' proposal reflects these rules and concepts and does not assume differentiation among shippers other than that which may result from individual choice or circumstance. Once a railroad achieves revenue adequacy, all captive shippers should be eligible equally for protection against further differential pricing consistent with the guidelines. However, individual shippers must elect to raise claims. Some may choose not to complain for various reasons. Some will be under contract and cannot complain, and each must make its own showing of market dominance. Under our proposal, the board's task is not to attempt to divide a hypothetical over-recovery pie. It is to ensure that the pie does not get larger at the expense of a specific complaining shipper. Question 4 asks for comment on proposals to tie revenue adequacy to the availability of broader competitive access remedies. The Allied shippers take no position on this question or on the matters at issue in Ex parte number 711 as they may relate to revenue adequacy. However, it is our view that any expansion of the availability of competitive switching or other access relief should not compromise a captive shipper's rights to rate relief under the guidelines or alter the rules for determinations of market dominance as a jurisdictional prelude to that relief. The availability of a potential alternative remedy should not serve to undermine those remedies that currently exist. Finally, question 5 asks about the impact of a revenue adequacy constraint on the railroad's ability to invest in their networks. As the Allied shippers foretold in our opening comments, the railroads as a chorus have proclaimed the end of reinvestment and the demise of the industry if a meaningful revenue adequacy constraint is adopted. At least insofar as our proposal is concerned, these claims are dramatically exaggerated and factually groundless. The Allied Shippers' proposal imposes no limitation on railroad returns at all. It simply limits the ability of a revenue-adequate carrier to impose further differential pricing on that relatively small segment of its customer base that is captive and takes up the burden of initiating a complaint proceeding. Inflation adjustments would preserve the carrier's margins even on this traffic, and railroads remain free to earn and retain all higher returns resulting from increased efficiencies, cost reductions, stronger pricing on competitive traffic, and other sources besides exploitation of captive shippers. In that regard, we note that the governing statute directs that increased revenues from competitive traffic should serve to reduce the cost burden borne by captive traffic, not increase it. Furthermore, under our proposal, the carriers would retain the ability to attempt to prove that the shipper in a particular circumstance should be exposed to a rate increase beyond real inflation if the specific need criteria set out in the guidelines are met. The logical end of the railroad's argument against any constraint that would, quote, limit returns, end quote, is that there can be no rate constraint at all predicated on a carrier's revenue adequacy. As we explain in detail in our comments, such an outcome squarely conflicts with the court-approved coal rate guidelines and the governing statute, including the rail transportation policy goals set out in Section 10101, Subpart 6. Moreover, as we showed in our comments, Professor Baumel himself has explained that standalone costs do not represent the gold standard for determining reasonable rates, but instead is an upper limit that does not preclude application of an alternative constraint when a monopolist already is recovering revenues at a level that allows its full sustainability. The record in this proceeding, including in particular the evidence submitted by the Allied shippers, clearly demonstrates that the railroads suffer from no shortage of capital and that on a current and prospective basis, they enjoy revenues that are more than sufficient to fund needed system investments. Their stock repurchase plans are just one indicator. In its comments, the AAR argues that such programs are not indicators of excessive revenues, but this is a straw man. The issue is not whether the railroad's overall revenues are excessive. It is whether they are adequate under the governing statute, such that captive shippers no longer should be required to absorb differentially higher prices. Assuming honest and efficient management, a railroad's decision to commit hundreds of millions or billions of dollars to the repurchase of equity is a strong indicator that management believes that it has more than enough revenue available to meet capital investment and other internal corporate needs. A revenue inadequate railroad, starved for capital, that chose instead to spend money propping up its stock price could not be considered properly managed. To the extent that the railroad's recent and remaining service problems are capacity related, we submit that they are a consequence of revenue allocation choices made in the past, such as efforts to right-size their systems, and not a shortage of revenues. Dr. Levine showed on opening and in reply that the railroads have had access to all the capital they need for many years. Captive shippers should not be compelled to continue to pay higher rates to make up for the results of the railroad's elections concerning whether and how to use that capital. Allowing revenue-adequate carriers to further increase rates on captive traffic is more likely to lead to increased equity buybacks and higher management compensation than it is to increased capacity or improved service. This concludes our prepared presentation. We thank the board and invite any questions that you may have.
Thank you for your getting back in practice. Thank you for your presentation. Commissioner? I'm sorry.
Thank you. So, Mr. Dowd, one of the things you talked about was that the 4-year period comports with a business cycle. But I'd like to hear you say a little bit more about it, because 4 years does seem a bit short if you're looking at even the last recession that we had. I forget when it was technically considered to have come to an end, but it certainly felt like it was more than 4 years. I'd just like to hear a bit more about why you consider that to be reflective of a business cycle.
Well, the concept of a business cycle can be seen as fairly elastic. And our reference to a 4-year cycle, a 4-year period as being reasonable, is tied both to precedent, the board's use of 4 years as a reasonable period in the 3 benchmark methodology, and also to the limited nature of our remedy. The remedy that we're proposing is to limit the ability of a market-dominant railroad to take increases above inflation in rates on a captive shipper's traffic. That is a very limited remedy both in scope and in nature. And as a consequence, the length of time that would be needed to measure the carrier's revenue adequate status does not need to be exceedingly long.
And I want to go back. I think you actually said this quite clearly in your testimony, but I want to be sure I understood. So when you talk about those remedies, is this correct that in your proposal, the shipper would have to, in essence, bring the complaint, they would have to show market dominance, and they'd have to show through their pleadings that the railroad was revenue adequate? Is that the way you laid that out?
Yes, and that's consistent with how we read the statute. The shipper has the burden of proof in order to secure rate relief from the board. And whether that relief is in the form of a rate prescription under the standalone cost constraint or a rate increase limitation under the revenue adequacy constraint, the shipper would, in either case, bear the burden of presenting evidence to support that. And
then your proposal that the limitation be that the rate can't be greater than inflation absent a showing by the railroad of why they need that increase would apply then only to those captive shippers who have in fact brought a complaint before the board?
That's our proposal, yes.
Thank you.
Thank you. That actually clarified a couple of questions I had as well. With respect to your comment about replacement costs, which I know can get a lot of people exercised, just saying those words, I think Dan and Deb are real familiar with that. But help me understand your perspective of why does it make sense that the board judges rates through the SAC process, for example, using replacement costs, but that we shouldn't use it to judge revenue adequacy? We also typically almost always allow historically replacement costs to be, or asset bases to be marked up after mergers, et cetera. So I'm just trying to understand the inconsistency, why that makes sense for judging rates one way, but judging railroad revenue adequacy another.
I'd like to ask Dr. Levine to chime in here. I've been dominating this panel so far. So.
Yes, thank you. It's my pleasure to be here. In regard to revenue adequacy and replacement costs, what we're dealing with here is essentially investor expectations. And when investors look at the array of opportunities, they're not looking at replacement costs at all. They're looking at historic book value cost for all companies. General accounting principles and financial principles and best practices are really the language of the business community. If you, for instance, if you access Jim Cramer on Mad Money on television, you'll never hear him mention replacement costs. If you look in the railroad's annual reports to shareholders or their proxy statements, you'll never see return on investment based on replacement costs. I've never seen a Wall Street analyst say, don't buy this stock because the return on investment using replacement cost is so much lower than the return on investment using book value. That's the language of the business community. It's the language that the investor sees and analyzes, and virtually all companies across the board use it. They're not using replacement costs in their end reports or in their financial reporting. And let me say also, the railroads, and I would urge the board, aside from reviewing the annual reports, the R1 reports that it receives, look at the annual reports and the proxy statements that the railroads file with shareholders in mind. Replacement costs are not a consideration. So to even the playing field, it's an analysis of return on investment traditionally for virtually the entire S&P 500 and everybody else. And that's, I think, what the difference is.
Yeah. John?
Commissioner Begeman, just to add a comment to your question about the how and why of this. The revenue adequacy is a top-down approach where you're dealing with the entire entity, the entire railroad. And the replacement cost issue is what is the cost of that entire railroad for now and for the future? In a standalone cost constraint test, it's a bottoms-up approach where what you do is you create a hypothetical railroad that is sort of custom-made hypothetical railroad. So it's bottoms up, you know exactly what you're pricing, and you price it directly. So there is an ability to say we have the following equipment, services, and whatever, and price it. So it's much easier. That's how it's done. In terms of mergers, the market actually puts a price on the value of that merger. So what's missing in the top-down is a market, an easy-to-reach market price. In mergers, a price is stated. You know what you're dealing with in terms of the price. Bottoms up, you have a specific railroad that you're pricing. So as the Commission has said for the past 30 years, the practicality of reaching a replacement cost estimate for railroads is very, very difficult.
Well, that I'm certainly familiar with.
Yes.
But I guess this is a topic that I hope that throughout the hearing that various witnesses will feel free to comment on, because I do see something of a disconnect, and I'm really trying to get as fully informed on the topic as I can. For the specific proposal you had with regard to how the constraint could be applied to judge a rate, if you could just give me a little more clarification. So if the rate is found to be unreasonable based, the shipper has shown market dominance and that a carrier is revenue adequate, and supposedly, assuming a railroad is unable to, meet the other two tests, which would allow it to raise or to, defend its rate against the shipper. Is it just that? Is this only brought under an increase? I mean, how is a rate prescribed? We haven't really determined what the rate should be. So is it that the shipper is only challenging an increase?
Well, that would depend on the claim brought by the shipper.
How would the board determine what the rate should be?
Well, under the guidelines and the board's prior precedents, it's very clear that the individual constraints under the coal rate guidelines can be brought collectively or individually. So if a given shipper experienced a rate increase and made the determination that it was unwilling to invest the time and the cost of seeking a rate prescription under the standalone cost constraint, for example, but its railroad was believed was revenue adequate, it could elect to file a complaint and attack only the increase that it had absorbed, which, as we foresee it, would be probably a shorter and considerably less expensive undertaking than a full-blown SAC analysis. In the alternative, a shipper who, and there's actually a case before the board now where this is the case, a shipper could bring a complaint both under the standalone cost constraint and under the revenue adequacy constraint, where it's urging rejection of a rate increase based on revenue adequacy, and then further a prescription of a lower maximum reasonable rate based on the standalone cost tests. So in the first instance, it would be up to the shipper to decide what relief it chose to seek and then present a case consistent with that.
So not to put words in your mouth, but are you saying that you're envisioning the revenue adequacy approach, constraint approach, only to be used to attack an increase or to target the increase? It's not to actually determine the process, for example, that SAC does, in which perhaps you would find you get all the way to a prescription where you determine what the rate should be, but rather you would bring a revenue adequacy case in order to fight an increase. Is that right?
Yes, our proposal would constrain the ability of the railroad to take additional rate increases on a particular shipper's traffic. I know that others in this proceeding have proposed remedies that would involve perhaps rolling back existing rates, and I'll certainly defer to them to address that.
And then if you could also just clarify something for me. For the two, I guess, things that the railroad would have to prove, such are the increased costs, so that and then the second one was that you could only get it from, I think you said that shipper, the increase. But I think I read in your in your written testimony or written comments, your filings, that it was you couldn't get it from any other source but captive traffic. To me, that's two different things. Is it just that specific shipper, or is it about captive traffic in general? I mean, are we going to be picking winners and losers of captive shippers?
No, I don't think that you would be picking winners or losers among captive shippers.
Would we only be looking at that particular shipper, or is the proposal that the railroad looks at, says that one of its defenses is that it needs it from captive traffic, or is it from that shipper? I wasn't clear.
Our proposal, it would be shipper specific. The railroad would need to demonstrate that for this particular traffic, it requires revenues that are greater than those that would be earned with inflation-adjusted rates, and then has to demonstrate what the need is. The specific need for the revenue, the reason why it has to get that revenue from this traffic, and why it cannot raise that revenue in any other way. And if the railroad is revenue adequate, it may be the unusual circumstance where those factors arise, but if they did, then the carrier would have the option to demonstrate the need.
And then, I guess, one final question, at least for now. You mentioned, with respect to the question of whether or not somehow revenue adequacy should be tied to competitive access. Although you said you didn't really have a position, the one thing that you did stress was that if a shipper were to have competitive access, it should not affect their ability to challenge rates. I think that's what you could still bring a rate case.
Our position on that is that the adoption.
You shouldn't be prevented from seeking remedies. I think that's what you said.
Yes. Our position is that if the board were to adopt expanded competitive access relief, the fact that that remedy was potentially available should not be used to undermine the shipper's ability to demonstrate market dominance in their particular circumstance and challenge the rate.
But how are you no longer market dominant if you had competitive access? That's what I'm trying to get to. I'm just not understanding. It seems to be a disconnect. Either you have competition, or you don't. I mean, either you're market dominant or you're not. You're not just.
If the board were to expand the availability of competitive switching, for example, there would still be a question in any particular circumstance whether that option actually provided legitimate, effective competition. The switching fee could be set at a level that makes it unattractive for another carrier to come in, for example. So our position is simply that the adoption of an expanded competitive access remedy in and of itself should not undermine the existing market dominance analysis. Whether and under what circumstances a specific shipper may have effective competition available would be based on the facts, presented in that case.
Thank you for clarifying that.
I wanted to ask a follow-up question related to competitive access. So I might be putting words into your mouth, but is the position of your clients that they didn't have a statement to make on competitive access today, is that an indication that they just don't see competitive access as having significant value?
No, our statement should be interpreted simply as the Western Coal Traffic League, Consumers Energy Company, and South Mississippi Electric Power Association don't take a position on tying revenue adequacy to a competitive access remedy.
Okay. Excuse me, one last question. So I wasn't here when the competitive access issue was before the board. Did WCTL take a position on competitive access then?
The position that the Western Coal Traffic League took in Ex Parte 711 is consistent with the position it's taking here.
Which means that
that the availability of an expanded competitive switching option should not be used to undermine the existing market dominance.
But does WCTL support the idea of expanded competitive switching?
I did not specifically participate in that proceeding,
Okay.
and I would be reluctant to characterize the details of its comments at this time.
Okay.
We can
Thank you.
provide that as a
Okay.
supplement.
Thank you.
Quick question, taking you back to the burden issue. I see that the shipper would be establishing revenue adequacy and market dominance, but then at that point, it sounds like it flips to the railroad. Wouldn't that create an Administrative Procedure Act burden problem by shifting the burden back to the railroads? Because it would seem to me that the burden initially would be on the railroads to show whether or not that increase was reasonable or not.
No, I don't believe so, Mr. Chairman, because the constraint, as we've proposed, would require the shipper to demonstrate market dominance and demonstrate that the defendant is revenue adequate. And that would be the merits phase, if you will, of a challenge to a rate increase under the revenue adequacy constraint. So the demonstration of revenue adequacy would give rise to then a rebuttable presumption that the rate increase is unreasonable. The railroad would then have the option of seeking to rebut that presumption. But that is not the same thing as putting the burden of proof on the railroad in the first instance. The shipper will have already carried its burden of proof under the two prongs for the constraint, market dominance and revenue adequacy.
So if we impose something like you're proposing, it's your position that we would be able to withstand an appeal, because I assume that's something that the railroads would raise at that point, that there has been a shift.
Yes, we believe that the constraint that we've proposed is fully consistent with the statute and should be sustained on review.
And is there any case law in a similar position? I know this is a very unique regulatory scheme, but are you aware of any case law that would support that?
I can't cite specific decisions for you, but the ICC and the STB in the past have used rebuttable presumptions in a variety of contexts, and the courts have not upset them.
Okay. And then following up on that part, it sounds to me, okay, it flips over to the railroads once you establish revenue adequacy. So it sounds like unless the railroads come back with something more or less that the rate increase, when it's revenue adequacy, for the most part, it's not going to take place. What I worry about is that, okay, we stop them going over revenue adequacy as far as revenues, But what happens on the flip side when they're not revenue adequate? There's nothing that balances the two. So here you're cutting them from going up, but there are going to be times when they're below the number, and they're not going to be able to do anything to make that up. So it seems like they're going to be at a disadvantage. Do you understand what I'm saying?
I think I understand your question, but
You don't like it?
no, to be perfectly frank, I don't share your concern.
Okay.
The constraint would apply to a single captive shipper's traffic.
Sure.
And the railroad, and in our example, we presume the railroad is revenue adequate. The railroad would have inflation protection on even that traffic going forward. If the fortunes of the railroad in the future changed and the railroad became revenue inadequate, and it desired to focus on that shipper, that individual shipper's rate and increase it, the board, as it does in all of these adjudications, retains the authority to reopen the matter. Under that example, one of the underpinnings of the relief is no longer effective. To it, the railroad is no longer revenue adequate. And I would think the railroad would have an argument on reopening that the constraint on its ability to increase that shipper's rate should be lifted. So there would be a remedy in that circumstance. But I think that given the narrow scope of the remedy that we're talking about, where it is a limitation on rate increases beyond inflation for an individual shipper who is part of a subset that Commissioner Miller suggested was only 5% of traffic, let's assume it's 10%. It's still a small segment of the railroad's overall traffic base. So the notion that the constraint we're proposing is going to somehow impact the overall revenue adequacy of the carriers, I don't think there's no logic there. I don't see that happening.
Can I ask a question?
Sure.
So how long does the rate, I'm just going to say cap because it's the only thing I can think, but how long does it stay in effect? I realize that there's the ability, the board still has control of some degree that it could reopen probably on its own or on a petition by the carrier, but otherwise, I mean, you know, we have, under SAC, your rate prescription is 10 years. I mean, how long would this rate, which isn't really a prescription, apply? Is it forever until there's some change in revenue adequacy or change in the need to, your costs, or how does it get to fluctuate?
Well, I think
And
you have
when?
to answer that question, I think you need to look at it in the context of what actually goes on out there in the marketplace. And if you look at, for example, the board's rate prescriptions, in the majority of cases where the board has prescribed rates, the full prescription period, which used to be 20 years, now is 10 years, very frequently does not run out. What happens is the parties are able to negotiate a contract which takes over, or there's a change in the nature of the traffic, or there are other changes that impact that commercial relationship. So while hypothetically, so long as the carrier was revenue adequate and so long as the shipper was continuing to make the same movement of the same traffic over the same route, the limitation on supra-inflation rate increases would remain in effect. Forever, I think, is not realistic because you're likely to have commercial relations between those two parties or other changes that'll impact the rates.
I mean, one concern I have from what you're saying, and feel free to try to convince me otherwise, and I hope others will comment on it as well, but you know, one of the things that you said from the beginning part of your testimony is that you're sort of envisioning this new rate process, you know, an easier process, not SAC, which for that I commend you for. But so I would, you know, this certainly would have the potential to be utilized much more than the few SAC cases that have come before the board in the past 20 years. I mean, this could become something that gets used quite frequently. And so there could be a whole lot of rates capped, not just the one, I can understand using just the one shipper example. That doesn't seem necessarily to affect the network and the ability to invest. But if this should become a very lucrative rate setting process, it could have a really big impact. So I'd like you to comment on that.
Well, I think that the impact is quite limited because you start with a small subset of the railroad's traffic, which is even eligible for the constraint. So whether it's 90% or 95%
But it
of
does
the
have,
railroad's
it
traffic.
could affect every captive shipper
And then within that subset, you have to eliminate those captive shippers whose traffic is moving under contract. And a considerable amount of captive traffic does move under contract. Parties are able to reach agreement on contracts even if there's no competitive alternative.
I
So
haven't
those are
heard that
removed.
very often.
I'm sorry?
I haven't heard that very often.
Well, in the marketplace, it is not at all uncommon for a single-served shipper, in particular an electric utility, to still have a contract with its serving carrier. So you eliminate the contract traffic, and then, of course, you have the traffic which is captive but is otherwise exempt. So there is a relatively small universe of traffic.
I think
that
that's
would be
what Deb got down to the 5% by kind of taking off a lot of.
Can I just add a
Sure.
Okay. Commissioner, let me just make this a bit more broad. The purpose of revenue adequacy is to constrain ultimately the Ramsey pricing that's allowed for these captive shippers under the Staggers Act. So there's always been the notion of revenue adequacy that at some point in time, the rates that this 5% or whatever the number is are paying to cover the overhead and fixed costs of these railroads. There will come a time, perhaps, where it's not necessary for them to be paying these high differential rates. So where we are right now is that it may be that time that the railroads are revenue adequate. So these rates that you're worried about for the future are historically much higher than the incremental costs of moving the traffic. Staggers allowed, the Congress allowed regulation to allow the railroads to recover their costs from these captive movements. And the stipulation in Staggers was that if and the ICC and STB, if the railroads become revenue adequate, then these captive rates should be constrained, in the future. So I think there was always this notion, sort of this quid pro quo, that when you become revenue adequate, you shouldn't expect to be charging as much for these movements as you have, as you have in the past, because your rates are much higher than the incremental cost. So it's just the broader perspective on why we're dealing with this issue.
Right, and that's what this is all about, trying to
Yes.
figure out what was intended, what is intended, what makes sense, what.
Yes.
All right, thank you.
I had another procedural question. With respect to, let's say you do the test that you've proposed, and in this instance, the railroad wins, and the increase is not found to be unreasonable. So at that point, would the shippers still be able to challenge the bottom rate from the increase? So let's say you lose on the increase itself, but what about the rate at that point?
Well, if the shipper's initial complaint included a claim that the existing rate was unreasonable under the standalone cost constraint, for example, then a finding that the railroad, for example, was not revenue adequate and therefore the rate increase would not be constrained under the revenue adequacy constraint, the shipper would still be left to try to press its claim for rate relief under the standalone cost constraint. The board and its predecessor held numerous times in the years following the adoption of the coal rate guidelines when it routinely considered rate challenges under all three constraints: management efficiency, standalone cost, and revenue adequacy, and frequently found that relief was not available under one or two of those constraints, but then provided relief under the third. Arkansas Power and Light case, for example, where the railroad was found to be revenue inadequate and the shipper's case under the management efficiency constraint was not upheld, but its claim under standalone cost was. So in your example, if the shipper had also pleaded a challenge to the underlying rate under a different constraint, that challenge could go forward.
I just want to clarify. So in my hypothetical, the railroad actually would be considered to be revenue adequate, although they saw the increase that they made to be reasonable because the railroad, let's say, lost a bridge, and they had to put a bridge in, and as a result, they had to increase their rates. That would be their argument, I guess. So at that point, if they determined that the increase was reasonable and the railroad's revenue adequate, wouldn't it be difficult to have a SAC test at that point? Because how can you say the rate's reasonable and then, I mean, the increase is reasonable, but the rate itself is not?
Well, I wouldn't want to speculate on the quality of the evidentiary presentation that a shipper in your hypothetical could present under the SAC test. But what I will say is that our proposal, consistent with agency precedent, is to add the revenue adequacy constraint as an available remedy for rate increases. The availability of the standalone cost constraint as a remedy for unreasonable rates generally and as a vehicle for rate prescriptions would remain fully available and fully in effect. Whether and to what extent a shipper's inability to demonstrate that it's entitled to relief under the revenue adequacy constraint could impact its standalone cost case, that's speculative, and I wouldn't go down that road without seeing the evidence.
Okay. One final question. Your proposal, and I think Ann hit on it, that it creates a simpler way for you to challenge something, a rate, in this case, an increase. Recently, and very recently, the TRB came out with a study that I'm sure everyone in this room is familiar with, and they suggested an alternative method, obviously, through arbitration, a rate comparison test. Let's assume that we can somehow bring that within the confines, something similar to a 3B test, but just a simple rate comparison test. Would that, if we use something like that in a revenue adequate instance, would you find that to be satisfactory? Something along those lines.
I just want to make sure I understand your question.
Sure.
Are you asking our view on a revenue adequacy constraint where once the carrier is shown to be revenue adequate, the rate is evaluated by reference to other comparable rates?
Yeah, I guess let me even broaden that. Let me just say, generally speaking, we create an easier way to bring a rate case. I mean, now we have the SAC test. I think everyone knows that those are very complex and difficult to handle. So what if we move more towards a rate comparison approach as opposed to a SAC approach, generally?
Well,
I left you speechless.
I don't want to appear to be avoiding your question, but the Western Coal Traffic League and Consumers Energy in South Mississippi, I couldn't express a position on that. We would have to see a specific proposal from the board and consider it, and I'm sure we would participate in a proceeding to consider it, but I wouldn't be able to speak on their behalf here on that subject.
Okay, I know it was a little off the track, but since it was out there and I have you here, I thought I'd ask you the question. Deb?
before we let you go, I've got two more questions I'd like to ask. So one, I want to go back to the inquiry Ann was making, but ask it a little different way. So, based on the numbers and the handy little pie chart I have in front of me, currently today about 5% of the traffic based on carloads is subject to our regulation. There's roughly another 14% of it that's under contract, but if not under contract, could be subject to our regulation. So I think where Ann was going, and the concern is if this process becomes simpler, faster, quicker, are we going to start to see a lot of traffic that currently is not subject to our regulation, but moving to put itself into a position to be subject to our regulation because they find that to be a better way to hold down their rates? And then would we not be talking about a small slice of the traffic, still not, a majority of the traffic, but a much bigger slice of the pie?
Well, first of all, our experience does not support the notion that shippers go out of their way to put themselves in a position where the regulatory scheme is their remedy. If they have the ability to contract, if they have the ability to negotiate acceptable commercial arrangements, they will do it. With respect to the scope issue, I would echo, Dr. Hennigan's response, which is that the notion that once carriers became revenue adequate, their ability to continue to differentially price their captive traffic was embedded in the coal rate guidelines. It has always been understood that when the time came that the carriers achieved revenue adequacy, they would then no longer be able to exercise continued differential pricing on their captive shippers. And if that time has come, and we believe that it has, that is the predicted and intended consequence of the coal rate guidelines as initially promulgated and court approved.
Could I just ask that, Commissioner? Whether it's 5% or 19% that you're concerned about, any shipper in that category, if they wanted to avail themselves of this procedure we're talking about, would have to come in, file a complaint against a rate, determine, prove market dominance, and then prove that the railroad's revenue adequate, which may already be a fact. But that's a affirmative burden on those 19% of traffic to come forward in a regulatory proceeding to take advantage of it. It's not difficult, but it's not a simple process, and it's shipper by shipper on particular traffic. So there's a constraint on sort of the use of this as a regulatory tool. It's leverage for the shipper in a way, but it doesn't necessarily translate into outcomes at the commission level.
Thank you. And then one final question. The way you have this process set up, that the burden is initially on the shipper to come in to show that there's market dominance, revenue adequacy, and then what's the term, a rebuttal presumption or rebuttable presumption would be on the railroad. So what do you envision would be the kind of argument a railroad might be able to make that would justify a rate increase above inflation?
There are a number of very experienced and talented railroad counsel in the room today, and I would encourage you to ask them that question.
Okay. Thank you.
Thank you very much. We really appreciate your testimony.
Thank you.
Thank you.
And we'll now call up panel 2.
So we're sort of balancing our seating a little differently from them to indicate to you. We're on a different side.
Microphones are shorter. Yeah. Brenner.
That must be me. Are we all set?
Why don't we hold on one second for the Commissioner to return?
Oh.
Didn't notice.
That's correct. That's correct.
Okay, you may begin.
Good morning, Chairman Elliott, Vice Chairman Begeman, and Commissioner Miller. My name is Sam Seibert. I'm outside counsel for the Association of American Railroads in Ex parte 722. AAR appreciates the opportunity to appear before the board today. With me on this panel are Edward Hamburger, President and CEO of AAR, and two distinguished economists, Professor Joseph Kalt and Dr. Roger Brenner. Each of us will be offering testimony on different aspects of the board's inquiry into revenue adequacy. I will make some brief introductory remarks and will later conclude our panel's presentation by responding to the questions set out in the board's notice of hearing. The premise of this proceeding appears to be that it could be appropriate to regulate railroad rates based on whether a railroad's overall revenues are deemed to make that railroad revenue adequate. AAR firmly believes that that premise is categorically wrong. Under the governing statute, revenue adequacy is an aspirational goal rather than a ceiling on rates. The concept was introduced into the statute when the nation's freight railroads were in a state of financial collapse. Congress' clear desire was to remove the regulatory shackles that had led to financial peril, and it instructed the ICC to adopt policies that would allow railroads to pursue and achieve financial health. Congress expected the railroads to do that through reliance on prices determined by the railroads set in response to shipper demand. Rate regulation standards like those advocated by the shippers in this proceeding that do not replicate competitive market outcomes would result in misallocation of resources and a gradual contraction of the rail network. Congress freed the railroads to act like other firms in competitive markets and to set rates in response to market demand. This freedom was implemented in part by significantly limiting the scope of rate regulation. The board is limited to evaluating individual rates for specific movements and may do so only upon complaint and only when a railroad has market dominance over the traffic. A top-down determination that a railroad earns adequate revenues across its entire system does not reveal whether any individual rate is reasonable. There has been much discussion in this proceeding of the suggestions in the coal rate guidelines that in a regulated setting, a railroad need not earn returns greater than its cost of capital on a system-wide basis. But as explained in AAR's comments, this inchoate revenue adequacy constraint was not grounded on any statutory authority or sound economic principle. Moreover, it has no coherent application to freight railroads whose traffic is predominantly unregulated. Let me emphasize that the specter of earnings regulation is not a straw man concocted by the railroads. The revenue adequacy constraint of guidelines could be characterized as contemplating earnings regulation, and that constraint is heavily relied on by shippers in this proceeding. All of the revenue adequacy rate regulation proposals advanced by the shippers are premised on the notion that there is something wrong with railroads earning more than their cost of capital. That notion points in the direction of earnings regulation, and it is incorrect. Now, it's possible that we will hear over the next 2 days, under questioning from the board, some disavowals of earnings regulation by shipper interests, and that would be an encouraging development. Nevertheless, the board should recognize that shipper proposals for making rate relief available on virtually all market-dominant traffic of revenue-adequate carriers are arbitrary, punitive, and economically unsound. Existing rate standards, most notably SAC, are predicated on economic principles that promote efficient allocation of resources through reliance on prices set in response to shipper demand. At this point, I'm going to turn it over to Mr. Hamburger, and I will conclude the panel's presentation later by responding to the specific questions the board noted for this hearing.
Thank you, Sam. Chairman Elliott, Vice Chairman Begum, and Commissioner Miller. On behalf of the members of the Association of American Railroads, thank you for the opportunity to appear before you this morning. AAR's members build and maintain the nation's coast-to-coast freight rail network, thereby ensuring that the U.S. economy functions efficiently and effectively, and that millions of passengers have reliable transportation when Amtrak and commuter trains access our rail lines. As Commissioner Miller noted in her opening comments, the partial deregulation that Congress and the Carter administration put in place 35 years ago literally transformed a dying industry into one widely recognized as the best in the world. Partial deregulation laid the foundation for the industry's success. It allowed the railroads to earn enough to make massive investments in rail infrastructure. This private investment allowed rail productivity to surge, leading to lower rates that in turn attracted larger volumes of new traffic, with freight rail competing head-on against other modes of transportation, such as trucking, pipelines, air cargo, and barges. These 2 days of hearings at the STB on revenue adequacy, quite naturally, are of huge importance to our companies, because whatever action you take will directly impact the financial well-being of the freight rail network and the industries and customers that we serve across America. Make no mistake, as you take up revenue adequacy, you are painting on a much larger canvas than just the inside of this room. What you are considering and may decide in this hearing room, just a stone's throw from the U.S. Capitol, will ripple across the economy and ultimately impact almost every American. This is not a hearing about an arcane formula of what constitutes adequate revenue at any given freight railroad. It is a hearing about the future of the U.S. economy. It is a hearing about whether our nation will continue to have a world-class freight rail system to propel its economic success. And yes, it is a hearing about whether you will let the U.S. freight rail system back on a trajectory of failure, back to where it was before the Staggers Act. And that is exactly why Congress in 1980 established revenue adequacy as a goal and not as a mandate to constrain the revenues of freight railroads. And now comes a handful of interest groups that want you to cut their transportation costs by direct government intervention at the expense of the greater good. Let's call it what it really is. They want you to institute a regime of wide-ranging price controls on freight railroads. The reason economists, and you'll hear later, are skeptical about price controls is that they distort the allocation of resources. When the marketplace cannot respond to increased demand, you get shortages and quality deterioration. And to try to prevent erosion of quality, the agency controlling prices then has to actively regulate service quality as well. At the end of the day, what that means for the rail industry is very simple. If you cap rail rates, you discourage innovation, productivity initiatives, and diminish revenue. And if you diminish revenue, you curtail the amount the rail companies are able to return to their networks, which currently is huge, $29 billion in 2015 alone, $575 billion since 1980. If you curtail this level of spending, then this agency could very well be responsible for the frustration of a number of important government policies and national goals. And I'm not being theoretical here. 7 very specific policy goals in danger should the board cap the revenue that railroads can earn by misapplying the concept of revenue adequacy. First, of course, is the policy of improving service. Less money to invest means that railroads will have to make hard choices. They will not be able to invest in building capacity in as many locales as shippers demand. That will result in less reliable service. Look at how the railroads responded to the service challenges in 2013 and 14, rapidly and with a huge infusion of capital. Demand will only increase. That's because the U.S. population is projected to grow by 70 million people by 2035, generating 2.8 billion more tons of freight, a 22% increase. Number 2, the policy of increasing exports. Exports help drive job growth and sustain the economic recovery. U.S. producers rely on our effective and affordable freight rail system to get their goods to U.S. ports to compete on world markets. Fully 1/3 of U.S. exports get to market by rail. The policy of achieving energy independence. Freight railroads are a key contributor in the effort to wean America off foreign sources of oil. By providing safe and reliable transportation, they have played a large role in allowing domestic oil production to flourish and for U.S. energy independence to become tantalizingly close. They accomplished this by being able to apply massive resources to the market to meet the changing commodity demands. They have also contributed to this goal by becoming the most fuel-efficient mode of land transportation, with each new, greener locomotive costing between $2.5 and $3 million. The policy of enhancing safety. Safety investments by freight railroads in tracks, switching and signaling systems, and yes, including $10 billion for positive train control. Bridges and tunnels and equipment have been and remain one of the most important ways to enhance rail safety. It is not a coincidence that the accident rate has declined 80% since 1980. A well-maintained railroad is a safer railroad. The other equally important factor to improving safety is recruiting and training the world's best rail workforce. The combination of investments and a well-trained, dedicated employee base led to 2014 being the safest year on record. Number 5, the policy of increasing freight railroads' share of freight traffic. In order to lessen highway congestion and to use a mode that is more energy efficient, reducing greenhouse gases, the National Rail Plan, prepared by the U.S. Department of Transportation, proposes a goal of having rail move 50% of all freight traffic transported over 500 miles. I will remind you that the cost of a new intermodal yard can easily exceed $200 million. The policy of improving on-time performance for Amtrak and ensuring reliable service for commuters. Demand for freight and passenger service will increase in the next 20 years. Since freight railroads serve as the operational foundation for much of America's passenger service, investments in the network must keep pace, or else service for Amtrak and commuter services hosted on our lines will deteriorate. And finally, the policy of increasing the resiliency of the national freight network. 2 major hurricanes that struck the Gulf Coast in 2005 demonstrated that the costs would be extraordinarily high for strengthening freight rail facilities vulnerable to the threats of rising sea levels and severe weather events. This lesson was driven home when Hurricane Sandy devastated the East Coast. I submit to you that these 7 very specific policy goals have broad bipartisan, executive, and legislative branch support. The common theme in meeting all of these policy goals is adequate revenue to maintain and expand the 140,000-mile rail network. And there is a direct correlation between what you decide in this proceeding and whether railroads will in fact have the necessary resources and correct incentives. In short, this board would be putting the attainment of these goals at risk by acceding to the demands of the handful of interest groups seeking to use revenue adequacy as a means for achieving far-reaching price controls. The U.S. Senate recently signaled the way forward for the STB. The STB Reauthorization Act of 2015, which was forcefully supported by many shipper groups testifying in this proceeding, was passed by the full Senate by unanimous consent in June. It would provide common-sense process improvements to allow the board to work more efficiently, and at the same time recognizes the need for freight railroads to provide billions of dollars in private spending so taxpayers don't have to. In fact, the bill explicitly states that in considering the concept of revenue adequacy, the board must consider the infrastructure and investment needed to meet the present and future demand for rail services. Nothing could be clearer. The U.S. Senate fully recognizes that if this board caps our revenue, thus moving in the opposite direction of this bill, then freight railroads will in fact not be able to meet the present and future demand for rail services. It took decades for the railroads to rebound from the brink of ruin. Decades and massive private investment. Indeed, the industry is an example of how private companies can provide sweeping public benefits. But decades of progress could be undone in the blink of an eye. Over these 2 days, you will hear detailed legal and economic arguments. They are important, to be sure. But let me urge you not to get caught up in the minutiae of these arguments so that you lose sight of the bigger picture that I have tried to paint here this morning. America wants to remain a global economic leader. U.S. government officials want to ensure energy independence. Passengers need to have access to state-of-the-art rail lines, and U.S. companies want to ship their products to new markets and create new American jobs. And right now, freight railroads are able to help attain these goals. We are able to help attain these goals right now because of thoughtful governmental leadership. Freight rail success today is due to the foresight of the government leaders in 1980 who unleashed the transformational power of the marketplace through partial deregulation. Subsequent federal involvement in rail economics, both in the legislative and regulatory arenas, honored the belief that a developed nation requires a top-notch freight rail system, and that that system is best provided by private companies in control of their resources rather than through the government. The message to you is clear. Continue to honor that belief. Thank you for your attention, and I'll now turn it over to Roger Brenner.
Good morning, Chairman Elliott, Vice Chairman Begeman, and Commissioner Miller. My name is Roger Brenner. I appreciate the opportunity to appear before the board in this important proceeding. I have a PhD in economics, and I taught economics at both Harvard and MIT, and I've spent the bulk of my professional career consulting for and advising U.S. firms on how to position themselves for financial success in competitive markets. My experience is directly relevant to what I understand to be one of the central issues in this proceeding, which involves what policies the board should promote in light of the improved financial performance of the nation's freight railroads and the possibility that they will achieve what the board calls revenue adequacy. The first point I would like to make is that comprehensive evidence confirms that railroad industry rates of return are not greater than market norms. They are less. The rail industry rate of return on investment has consistently, for the past decade, been substantially lower than that achieved in the private sector by other relevant reference industries. As I described in my written testimony, my calculations based on widely used Bloomberg data, and I cite that just because it is a high-quality source. It's checked by firms themselves because they want to make sure the reporting is accurate. So it's a widely respected database, show that railroads earned a 7.2% return on average in the past decade, 2004 to 2013. Other industries with similar economic characteristics have fared far better. Aerospace and defense earned 15.7%, pharmaceuticals 15.4%, and electrical equipment manufacturers earned 15.6%. Exhibit 1B from my opening statement shows that the railroad industry return on invested capital has been consistently below that of these other industries since 1998, and the exhibit we've reproduced here just reminds you of that. In contrast to the large gaps between rail and peer returns, each of these peer sectors had costs of capital very close to that of rail. Exhibit 2, reproduced here, compares the weighted average return on invested capital of railroad to industries with similar economic characteristics. By the phrase similar economic characteristics, we're referring to the critical characteristic that each of these comparables to rail requires massive capital expenditures in the course of ordinary business operations relative to other sectors. In other words, the rail industry's achieved lower rate of return is not attributable to a lower cost of capital or other economic characteristics that would logically differentiate its normal defensible return from returns of meaningful peers. The highlighted area there just shows you comparable costs of capital, and you'll note that rail sits about half the 15% level of these reasonable reference industries. So that leads us to the second important point I would like to make. It's perfectly normal for an industry to regularly earn more than its cost of capital, both as a matter of economic theory and empirical experience. The rates of return in most other industries clearly show that firms in a competitive market are not limited to earning an average return equal to the weighted cost of capital. The ROIC for most industries in the graph is well above the corresponding cost of capital identified by the diagonal line. This is certainly most dramatically true when the economy is near full employment and all invested capacity is fully utilized, but is equally true when looking through a full business cycle. In competitive markets, the average ROIC should exceed the weighted average cost of capital according to theory and does so according to sound data. A critical socially beneficial role of firms in the U.S. economy is to seek and develop attractive investment opportunities and pursues those that have expected returns at least equal to the cost of capital, equal to or exceeding. By simple arithmetic, if you pursue all projects promising more than or at least equal to the cost of capital, and you pursue none offering less than the cost of capital, your average expected return must be greater than the cost of capital. It really is that simple. The prospect of returns exceeding the cost of capital spurs innovation through prudent risk-taking, and these investments lead to the productivity improvements necessary to raise the American standard of living. Now, the notion that a firm subject to regulatory oversight might be penalized for or prevented from achieving an average return above the cost of capital is irrational. What would the regulator want industry executives to do to match but not exceed the cost of capital? Would you like them to pursue too many projects, including those not expected to cover the cost of capital, so as to reduce the average? No. Would you want them to execute those opportunities potentially earning more than the cost of capital, but do so in an inefficient and cost-squandering manner so as to cut the realized return? No. Instead, wise regulation would encourage rail executives to pursue the right opportunities efficiently, earn a higher than cost average return, and be able to attract the market capital to build out and sustain the rail industry America needs. Capping returns at the cost of capital would undeniably create truly perverse incentives and asymmetries versus the rest of the economy. This would undeniably lead to too little capital attracted to rail, and that capital which was attractive would be encouraged by the regulator to be poorly managed. This discussion broadly explains why successful firms can be expected to earn more. Moreover, it summarizes detailed firm-specific behavior witnessed in the budget cycle of very many well-managed firms. In the next exhibit, I show you the type of discussion I have witnessed and which railroads and every industry pursues during their budget cycle. They get requests for new investments from all their divisions. They sort them. They rank them. And in this example, I say, all right, the top yielding, project number 1, is asking for $700,000. The scale doesn't matter. They're illustrative with reasonable rates of return and relative values. And this project, because it perhaps is very important to this firm, yields a 23% rate of return. In a rail industry example, perhaps this would be relieving a bottleneck that's come because of a surge of unexpected traffic. And so the high volume with fixing a bottleneck would give you a high rate of return. So that 23% is associated with the $700,000. And so the cumulative ROIC is just the ROIC on that project. If you keep layering in the incremental projects, you'll see by the time you get to the 6th project, which has an 11% rate of return with a comparable investment, the investments have accumulated to $4 million, but the average return is 17. 17 is just the average of the 23, 21, 19, 16, 14, and 11. That goes on everywhere. And then they look at the next project and they say, you're only offering us 8%. Now, our cost of capital is a given number. We know from experience that not all projects work out as well as they hope, that project managers have a certain amount of unbridled optimism, perhaps, when they bring forward a project in their division. So we set a hurdle rate that's a little bit above our official cost of capital. So in this example, I say 11. So that's their cutoff point, and they reject all below 11. That's how you get to an average return that's higher than the cost of capital. Now, this is for one project cycle, 1 year's budget meeting. You repeat that over the life of the enterprise, and of course, the average of the average is the number that you come up with. Now, this isn't just tied to capital budgeting. I'd be happy in Q&A to show you how this phenomena of the average value being far higher than the cost is pervasive in your own personal behavior. It's a notion known as consumer surplus. So we can explore that if you feel uncomfortable with this. So if railroads were regulated to cap their average rate of return at their cost, they would be put at a disadvantage as they strive to attract sufficient external investment dollars, because they'd be asked to do something very different from what every competitive industry does. Now let me switch topics and speak briefly about the subject of financial metrics. The board correctly looks at return on invested capital to assess railroad revenue adequacy, although I do believe it measures the asset values somewhat incorrectly. Some commentators and testifiers suggest that the board should abandon the use of ROI or extend beyond it and look at short-term financial metrics that are prevalent in the media, like railroad stock performance or the 6 other metrics that Mr. Levine suggested. I often tell the students in my economics and finance classes, if you just read the paper, your economics IQ is severely threatened. The journalists aren't trained finance or economics people. They will talk about anything that seems to them to be interesting, whether it has any theoretical relevance. And I'm afraid, as I remarked in my counter to Mr. Levine's testimony, that's what it feels like he was doing today, or doing to you. Railroad stock performance has improved over the last decade, and those who invested at the right time have certainly benefited. But the improved performance of railroad equities reflects improved railroad performance from a very depressed starting point, not supernormal earnings. This exhibit shows you the price-earnings ratio, and you see how from 2000 to 2013, this was the data that was available when I prepared my testimony in the middle of last year, finally the rail price-earnings ratio came up to match that of the Standard & Poor's 500 aggregate. For 2014, last week, I pulled the data together, and rail has now once again fallen below. I show you this not because I'm recommending it, but just to show you that the multiple of earnings today is in the neighborhood of the aggregate, but it's far from being regarded as excessive. Other financial metrics like return on equity or operating ratios provide only partial and often distorting information about financial performance. ROIC is the core measure of financial performance that must be assessed to determine long-term financial viability and to provide meaningful comparisons of financial results across industries. Some commenters point to the railroad's ability to pay dividends and to repurchase stock as evidence that railroads have excessive earnings. But such uses of funds are appropriately pervasive throughout the economy. Investors look to firms to provide both short and long-term returns for the investor's commitment of capital. In the short run, investors often want to see a portion of cash flows immediately returned to them as dividends or reflected in improved prices created by current share repurchases. In the long run, investors also expect sufficient funds to be reinvested in the firm to keep the firm competitively modern and to expand its capacity commensurate with market growth. Such reinvested capital eventually improves earnings and thus improves share prices to give the investor a long-term return. As I know in my testimony, the exact chosen mix of these three uses of funds, dividends, repurchases, and capital spending, at any point in time for any firm depends on the economic and financial situation of each firm and of the national macroeconomy. But despite the board's appropriate use of an ROI standard, its current approach to evaluating railroad ROI produces misleading results. The board's calculated results are, in my opinion, systematically overstated to the use of depreciated original cost asset values and the treatment of deferred taxes. Economists and investors both know that the rate of return should be calculated using the replacement cost of assets. Investors evaluate investment opportunities based on the current cost and market value of assets rather than the original decades-old cost of assets. The board's treatment of deferred taxes is also not consistent with the manner in which investors consider deferred taxes when they evaluate investment opportunities. Investors in other industries expect to earn a return on deferred taxes, so deferred taxes are left in the asset base when measuring return on investment, such as in the Bloomberg calculations I shared with you. The board, on the other hand, excludes deferred taxes from railroads' investment base and thereby overstates the potential attractiveness of railroad industries' investments relative to other industries. The final point I would like to make today is that railroad revenue adequacy should be evaluated over the full service life of assets. The economic value of an investment needs to be determined over an appropriate life, such as its service life. By examining investment, by doing so, the returns can be calculated across a full and relevant range of economic, financial, and competitive conditions. Use of a shorter snapshot time frame to assess performance can and probably will result in an incomplete and unreliable assessment with no guarantee that, as they say in the financial press, past performance are indicative of future performance. As I explained in my written testimony in this proceeding, railroad assets have exceptionally long lives. According to statistics published by the Bureau of Economics of the U.S. Department of Commerce, rail equipment service lives are 28 years, and railroad structure lives range from 38 to 54. To determine whether returns are sufficient to replenish rail assets, the STB would need to take account of the long lives of these rail assets. This morning, the shippers allege, contrary to all facts, that 4 years is a reasonable business cycle. I stifled laughing. Since 1959, we have 7 recessions of various degree. So we got 56 years and 7 recessions. I would call that 8. All right? And in fact, some of those were minor recessions. If you look from when the economy got to full employment in 1969 at 4%, the next time we got to 4% was 1999, 30 years. There are wide varieties in business cycles, and picking just one with an average of 8 years will give you a somewhat arbitrary representation for an industry whose service lives are so long. In conclusion, I would emphasize that the available evidence indicates the railroads are not earning excessive returns and should not be punished for improved financial performance by restrictive regulation that inhibits them from behaving the way other firms reasonably do in competitive markets. Thank you very much. Mr. Call.
Thank you very much. And thank you for allowing me to speak to you today. My name is Joe Kalt, and I am the Ford Foundation Professor Emeritus of International Political Economy at the John F. Kennedy School of Government at Harvard University. Throughout my career, the economics and regulation of the railroad industry have been key issues addressed in my work. And at the risk of sounding a bit like a pedantic professor, which I am, I'd like to begin with some discussion of some of the basic economic principles at work here. In particular, this proceeding raises the broad issue of whether the board will continue to embrace economically sound methods of rate regulation. The starting point for addressing that question is the core principle that the public interest is best served by rate regulation that seeks to replicate competitive market prices. Competitive markets compel sellers of goods and services to produce what they offer consumers at the lowest possible cost. Competitive markets also propel sellers of goods and services to figure out what the consuming public wants and needs, inducing sellers to tailor their goods, their services, and their pricing appropriately. Competitive markets operate by price and profit signaling, showing consumers low prices where supplies are more abundant and higher prices where costs make supply more difficult to provide. At the same time, competitive markets show sellers opportunities for higher profits through expansion where strong demand is tending to hold prices above costs and to discourage supply where the opposite occurs. Based on these most basic of economic principles, rate regulation, which serves the overall public's interest in a healthy and efficient economy, only imposes rate caps where competition is absent and where regulation can be more effective in pushing prices to the levels they would have if competition were present. The centrality of competitive market prices to the public's interest in a healthy and national economy is not some mere ideological predilection. It is undergirded by decades of Nobel Prize-winning economic research. In fact, the competitive pricing standard is behind the revolution in economic regulation that has taken place in the U.S. and in most of the rest of the world over the last several decades. Old-style public utility or earnings-based regulation, that is, franchise monopolies with their rates or prices regulated to produce revenues just adequate to cover their accounting book asset values plus a cost of capital. That old style of regulation has largely been abandoned because it distorted market forces and ultimately harmed the consuming public. In fact, the Staggers Act is a premier example of the successes of regulation, which employs the standard of letting markets determine rates when competition is present and seeking to reproduce competitive pricing through regulation only when it is demonstrated that market dominance is present and being abused. Various shipper proposals in this proceeding would have the board impose rate caps of some form based on a carrier's overall level of revenues or earnings. These proposals are not founded on the principle that regulation should set rates which equal competitive prices. Indeed, these proposals are not even founded on economically coherent principles of revenue adequacy. I say this for several reasons. As Dr. Brenner has just discussed, the economic evidence does not support assertions that carriers are or soon will be revenue adequate. Such assertions are based on improper and economically flawed measurement of the concept of revenue adequacy. Proper measurement of revenue adequacy would be based upon the answer to the question of what overall revenues a contestable, that is a competitive, market would provide to what I term in my written statement a system-wide standalone railroad. That is a system-wide SAR seeking to provide the same service, perhaps more efficiently, as the incumbent. As Dr. Brenner noted, this basic economic principle is contradicted by attempts to measure and assert revenue adequacy based on comparisons of carriers' market cost of capital to their rates of return calculated on the basis of depreciated book values of often long ago invested capital. We often illustrate the flaw in this much abused historic book value approach with the case I discuss in my verified statement. Consider the case of an older, fully depreciated apartment building. Based on historic book value, a fully depreciated apartment building will be calculated to be earning an infinite rate of return, even if it can and does charge no more than competitive market rents for its units. If that apartment building's rental rates were capped based on revenue adequacy defined by historic depreciated book value, our depreciated apartment building would have grossly excess revenues and would have its rental rates driven towards zero. We would then expect the quality and eventually the very existence of that capacity to deteriorate. Such regulation would be economic nonsense. The public interest demands that the apartment building be able to charge the rental rates determined in the competitive, unregulated marketplace. Holding prices below competitive levels ignores the fact that the owners of capital, whether it be railroads or an apartment building, have to themselves compete in capital market for the capital they need. Tying their hands with below competitive prices ties their hands in competing for capital. Initially, of course, in my hypothetical here, customers love it. That is, the renters in the apartment building love having rents depressed below competitive levels. But the example that I'm giving is not just the teaching device of this pedantic professor. It is, in fact, the disastrous lesson behind every inner city in the United States where the argument has prevailed that those landlords are rich enough, they have enough money, we can depress the rental rates below competitive levels. Applied to railroads, the principle of competitive pricing in a healthy and dynamic industry means basing revenue adequacy on the revenues of a contestable market would generate to cover the replacement costs of an efficient system-wide SAR. It is telling in this proceeding that no responsible party is telling you that replacement cost is not the economically correct measure. Rather, you're being told it is too hard to calculate and implement. But engaging in economic nonsense because doing what is correct is too hard is the foundation for unsound policy in which parties from any side, carriers, shippers, have the ability to manipulate policies that are untethered from sound economic principles. An economically coherent concept of revenue adequacy recognizes that in a dynamic and ever-changing economic environment, the revenues of a contestable competitive market would yield to an efficient standalone railroad would represent a minimum target of policy. As Dr. Brenner has stressed, sometimes professor, the competitive market standard does not preclude, as shipper commenters in this proceeding universally assume, a competitive market standard does not preclude a railroad's realizing earnings greater than its cost of capital, even over an extended period. When they provide superior service, responsiveness, innovation, and/or skill at anticipating shifts in market dynamics, shifts in customers' demands, firms in competitive markets can readily earn and sustain revenues in excess of their cost of capital. You've seen Dr. Brenner's data. Under such circumstances, earnings in excess of the cost of capital will be associated with expansions of capital and the services the public demands. This is a good thing. It represents the market using its profit signals to channel services and investment toward where consumers are signaling they want more service. What we should worry about is not earnings in excess of the cost of capital that arise because a carrier is meeting consumers' demands and expanding services to consumers. Instead, what we should worry about is earnings in excess of the cost of capital that arise because a company has market power and is forcing prices higher by artificially withholding supplies from the marketplace and thereby driving prices and earnings above the competitive levels. The latter does not describe the railroad sector. Far from withholding investment and supply, under the Staggers Act, the class-run railroads have been second to no other industry in investing and expanding service to consumers. Over the last decade, investment as a share of revenue by class-1 railroads has been 3 times or more than most any other industry in the U.S. economy. In addition, and echoing this, the professional research literature consistently concludes that the economic evidence does not support assertions to the effect that the improvements in carriers' financial health over the last decade, whether to the point of revenue adequacy or not, the research does not say that these improvements in financial health have been the result of abuses of market power, which have gone uncurbed by the board's rate regulation authority. Indeed, for the reasons I have stated, a finding of revenue superadequacy, earnings in excess of the cost of capital as it is currently interpreted, would not tell us that any of our railroads' rates were above competitive levels. Whether or not market power abuse is present can only be determined by factual inquiry into the conditions pertinent to specific traffic in specific markets. The board's policies have consistently recognized this. There is no economically meaningful metric that would enable a quick, wholesale identification of traffic that is subject to abuses of market power. For example, there is no basis for concluding that just because particular traffic has rates which yield revenue-cost ratios in excess of 180, or some trigger value of RSAM, or any other test metric, just because that metric is exceeded, that cannot tell us whether such traffic is actually captive and being victimized by some railroads' exercises of market power. In short, I find that the shipper proposals to implement revenue adequacy constraints are unsound. Proposals to regulate rates based on a carrier's overall level of revenues would untether rate making from the board's long-standing policy of employing rate maximums only where they are needed because abuses of market dominance are preventing prices from being kept at the levels that competitive markets would otherwise set. A cornerstone of the board's SAC test approach to rate making has been the recognition that by invoking the standard of contestable markets, it prevents distortive cross-subsidies. Attempting to regulate individual rail rates based on system-wide revenues, as opposed to competent analysis of individual markets' competitiveness, relative and testing rates relative to a competitive standard as provided by the SAC test, would certainly create undesirable cross-subsidies. Proposals, for example, to rebate putatively excess revenues to purportedly captive traffic would inevitably leave competitive traffic subsidizing regulated traffic. Similarly, limits on differential pricing triggered by putative findings of revenue adequacy, as opposed to being triggered by violation of a competitive price standard, such limits on differential pricing would be expected to leave traffic on lower cost, high density lines, subsidizing traffic on higher cost, low density lines. Differential pricing on the basis of other than the kind of Ramsey pricing that contestable markets would generate inevitably falls back on non-economic assertions of fairness. And this inevitably devolves into expensive litigatory and political contests among interested parties. Suggestions that rate capping based on some application of system-wide revenue adequacy would hold down regulatory costs are unfounded and unproven. Perhaps even more importantly, untethering rate regulation from coherent economic principles would emaciate the standards that can otherwise be employed to rein in the demagogues and to cut off the extremities of purely self-interested argument. Specific shipper proposals to freeze rates or to impose rate caps on putatively revenue-adequate carriers are not consistent with competitive market standards. One way or another, such proposals would entail the imposition of price controls on part or all of a carrier's traffic, competitive or captive. As such, they inevitably interfere with the critical role of prices in signaling rational behavior by sellers and buyers. The track record of price controls, from the regimes of price controls tried by President Nixon to the dilapidated rent control departments in many inner cities, is quite clear from mountains of economic research. Where price controls hold prices below the levels that contestable competitive markets would generate, the outcome is inevitably one of discouraged investment, artificially encouraged demand, and ultimately shortages of quality and quantity. As one Nobel Prize-winning economist put it, we economists don't know much. I don't like him saying that. We economists don't know much, but we do know how to create a shortage. If you want to create a shortage of tomatoes, for example, just pass a law that retailers can't sell tomatoes for more than 2 cents per pound. Instantly, you'll have a tomato shortage. The railroad industry is in no way immune from these economics. In fact, the industry is inherently susceptible to what has been called regulation of a sitting duck. Because of its extremely long-lived capital, the industry is a sitting duck for policies in which myopically self-interested parties gradually eat away at the system with destructive policies whose disastrous consequences do not show up for years or decades. In fact, this pretty much describes what happened to the railroad industry in the pre-Staggers era. Railroads were first encouraged to invest and build. By the early 20th century, they were the envy of the world. But once the investments were in place, we began a long process of eating away at the installed capital until the system, the sitting duck, was effectively killed. We left it to later shippers and later policymakers to deal with the consequences. Let me conclude by saying that none of this is to say that the board should not be vigilant in regulating where exercises of market power are demonstrated. Quite the contrary. The fundamental principle of replicating competitive prices demands such vigilance. At the same time, moving away from the board's longstanding principles of using regulation to set railroad rates where abuses of market power prevent prices from being set at levels competition would otherwise dictate. Moving away from that standard would be directly contrary to the public's interest in a healthy national economy. Doing so would also threaten the gains that have been made under the board's implementation of the Staggers Act. The ongoing expansion of the nation's economy demands of the rail sector the ongoing expansion that the nation's economy demands of the rail sector would be directly threatened by prices which distort shippers' choices over quality and modes of transportation, and which distort carriers' investment decisions. Rate regulation, misguided or by mismeasured and misapplied criteria of revenue adequacy employed to impose price controls, could only exacerbate the challenge of generating the capacity needed to avoid shortages. We could pretend that the industry's long-lived capital will last forever, and that we already have enough to meet the growing demands of the nation's economy. But the rail industry has to compete in the capital market for investors' dollars. Employing some notion of revenue adequacy to limit rates below competitive levels because railroads purportedly already make enough money could only tie their hands in the competition in the capital market. The board's SAC test already provides an objective standard for assessing whether rates for specific rail traffic are found to be subject to market dominance are consistent with the competitive market standard. An objective measure is necessary to control demagoguery and outright stupidity, and to avoid arbitrary and economically unsound regulation. The challenge that remains is to work directly on improving the board's procedures for implementing its SAC tests and the associated standard of competitive market pricing. My experience at the Federal Energy Regulatory Commission with the use, for example, of technical working groups, i.e., not lawyer working groups, all due respect, suggests that there are, in fact, viable processes that minimize disputes and could aid in the approach to such challenges as coming up with, in fact, workable and implementable systems of a competitive market pricing standard. But calls for jettisoning such standards and the other elements of the board's competitive market pricing standard are a diversion from this task and threaten the public interest. Thank you.
Thank you, Joe. Let me finish our panel's presentation by addressing the questions the board identified in its notice of this hearing. You've heard our other witnesses already address some aspects of these specific questions posed by the board, but I want to address each question sequentially so that AAR's position is clear on the record. First, you asked the parties to address the proper time frame for evaluating revenue adequacy. I would distinguish here between evaluating and regulating because, as you've probably gleaned, we don't think it's appropriate for the board to be regulating rates based on a finding of revenue adequacy over any time period. As for evaluating, Dr. Brenner has demonstrated that railroads have very long-lived assets. These asset lives considerably exceed the length of a business cycle, however you might measure it. It would therefore be more appropriate to evaluate railroad financial performance with reference to average railroad asset lives than business cycles. As AAR pointed out in its written comments, the railroad's electric utility customers have taken that very position before their own regulators. Second, you asked whether the board should consider requiring a revenue-adequate railroad whose increased rate has been challenged to justify the increase on a complaining captive shipper. And I believe, Chairman Elliott, your question about burden of proof under the Administrative Procedure Act may have some relevance to that question. And let me just state so the record is clear that we believe that the proposal Mr. Dowd was setting out this morning would be inconsistent with APA requirements by shifting one critical element of the proof of unreasonableness from the railroad to the shipper. Professor Kalt has explained imposing what could amount to a rate freeze on market-dominant traffic by requiring revenue-adequate railroads to justify rate increases on such traffic would be unsound policy from an economic perspective, nor could such a requirement be reconciled with not just the APA, but with ICTA. That statute does not permit the board to assume a rate is unreasonable just because a railroad is market dominant, nor does the statute permit the board to conclude that an individual rate is unreasonable simply because a railroad's system-wide earnings exceed the cost of capital. A nexus between a particular rate and a railroad's earnings in excess of the revenue-adequate level cannot be assumed. This is especially the case since the substantial majority of railroad revenues are attributable to unregulated traffic. And that proposition has already been the subject of some observations by Commissioner Miller and some back and forth as to what the actual percentage of unregulated traffic is vis-a-vis regulated traffic. All of us agree, whatever the precise number is, all of us agree that the substantial majority of rail traffic is unregulated, not within the board's purview, and the notion that we somehow could be having system-wide earnings determining the outcome of individual rail rates presents, to use another word that has come up a couple of times this morning, a disconnect. Third, you asked whether a revenue-adequate railroad's ability to differentially price should be limited for all captive shippers or for a subset of captive shippers that are most likely to be subject to the railroad's market power. And I should insert a caveat here that my use of the term captive shippers violates a commandment I've received from one of my co-counsel, but I do so because the board used the term. I don't want to be hoisted on that petard. In any event, the answer to that question is emphatically no. Limits on differential pricing should be based on whether a rate is reasonable, not on whether a railroad earns revenues that exceed the cost of capital. The statutory prerequisite to a rate reasonableness inquiry is a finding of market dominance. There is no shortcut to determining whether a rate is reasonable via some presumption regarding the extent to which a shipper is subject to market power. Fourth, you asked what competitive access remedies would be appropriate and consistent with the board's governing statute when a railroad is revenue adequate. Our position is that there is no logical connection between access remedies and revenue adequacy and no basis for a connection in the statute. And as the case law makes clear, the board is not empowered to regulate rates through access remedies. That's the Mid-Tech case both before the ICC and the DC Circuit. Access remedies were intended by Congress to address market power abuses that were not related to the level of the rate charged. AAR and its member railroads also presented overwhelming evidence in the Ex parte 711 proceeding about the service problems that would arise under a forced access regime such as the switching proposal presented by Knit League. Those problems would exist whether or not a railroad is revenue adequate. Fifth, in a question apparently addressed to shipper interests, you ask about the impact of revenue adequacy proposals on railroads' ability to invest in their networks, taking into account the service issues that arose last year. And Mr. Hamburger has already spoken to that. You heard from him about the importance of and need for additional investment in railroad infrastructure. You've heard from Professor Cald and Dr. Brenner about the economic principles that govern market-driven investment decisions. The math is simple. Firms don't make capital investments unless the investments have the potential for earning returns that exceed the cost of capital. That potential is necessary to offset the inevitable shortfalls that occur, for example, when we have a deep recession as we did within the past 10 years. Regulation that prevents railroads from consistently earning at least their cost of capital will result in less railroad investment than the market calls for. Lower investment levels have obvious implications for the quality of service that railroads are able to offer and the amount of capacity they're able to provide. Finally, I would like to address a question you raised regarding the board's methodology for determining revenue adequacy that appears to straddle the line between Ex parte 722 and Ex parte 664 sub 2. As you've heard from Professor Cald and Dr. Brenner, accounting rates of return based on historic book value do not give an accurate picture of the economic returns being earned by a company. Economic rate returns can only be determined using the replacement cost of assets. In conclusion, let me reiterate the three main points AAR would like you to take away from our panel's presentation. Mr. Hamburger explained why the board's implementation of a revenue adequacy constraint would pose a serious risk to several vital national policy goals, including preeminently the need to continue to invest in an expanding rail network that is a vital engine of American economic growth. Dr. Brenner demonstrated that far from being excessive, rail returns have been below the norm for the past decade, and that railroads need to have the incentive and opportunity to earn substantially more than their cost of capital, as most firms in competitive markets regularly do. And Professor Cald explained why shipper proposals to regulate rates based on a carrier's overall level of revenues through various forms of price controls are inconsistent with competitive market principles and would lead to misallocation of resources, underinvestment, and gradual deterioration of the rail network, albeit very slow deterioration perhaps. None of us might be around, but that doesn't mean that we shouldn't be worried about saddling future generations of transportation users with a system that is not going to make it in the long run. The board has the opportunity in this proceeding to promote the broad public interest by endorsing the continued growth of a rail industry that is able to replenish its assets and expand to meet market demand through private capital investment. The board should seize this affirmative opportunity. It shouldn't penalize railroads for having made progress towards sustainable financial health. Thank you very much for your attention, and our panel will be happy to try to answer any questions you may have.
Thank you all for your testimony, and I hope that my question shouldn't be interpreted that I wasn't listening. But Just a couple questions I'd like to ask, because you were fairly clear on your testimony, and Mr. Sipe, you really did consolidate sort of the main points for us. So thank you as far as what you wanted to convey. I would like to know what the industry's perspective is as far as what do you believe the purpose is behind the board's annual determination of revenue adequacy, which we do according to the statute?
The purpose is to get some sense of rail financial performance, whether that financial performance is on the uptick, whether railroads are making progress in terms of becoming financially healthy, whether there is a reasonable prospect that they're going to achieve the congressional goal of being able to recover their full costs and invest in replacing and expanding their assets. It's like a yardstick or a measurement. How are we doing year to year? In fact, I think the very fact that the statute calls for a yearly determination indicates that they weren't thinking of some long-term assessment of should there be a category for determining how we regulate rates that is based on financial health, because everybody agrees that can't be limited to a one-year view. But if you take a trend line of snapshots, and that's what we've done since Staggers, the message is very clear to everybody that the railroads have been getting financially healthier, and that's a good thing.
And you mentioned the other proceedings that were tied with this, as far as the board's methodology for determining the cost of capital, and which of course goes into revenue adequacy, et cetera. And I think your message was that replacement costs are something that the board should, or the combination of your messages was that just because it's hard, it doesn't mean that it's not accurate. Could you comment on how and before my time on the board, I know that AAR had petitioned this agency to do a proceeding and to look at replacement costs, and ultimately that, I think it was rejected somewhat for being too hard. I don't want to misrepresent that since I was not here at the time, but please comment on how could it even be accomplished reasonably?
Well, let me take an initial crack at that, and then maybe Professor Colt would like to speak to it. I was counsel to AAR in that ill-fated petition. You've silenced me, Mr. Hamburger. I think your characterization of why the board rejected our replacement cost approach is accurate. It's probably fair to say there were some holes in our proposal, but I don't think it was Swiss cheese. It wasn't riddled with holes to the extent that it's irreparable. I think that if we had a serious proceeding designed to come up with a methodology for determining what in effect would be something like a system-wide SAC for the railroads, that we could get there. And if you have any inkling that you might want to regulate rates based on revenue adequacy and that you could lawfully do so, which we disagree with those propositions, but if you have any inkling that you might do that, then you better get the measure of revenue adequacy right and use the right asset base so you're not imposing remedies on carriers that are not, in fact, revenue adequate.
Well, I'm newer to this than many of my colleagues, and when they asked me to help understand rates of return and so forth compared to other industries, I didn't know it was difficult to do replacement cost accounting. So I turn to my familiar turf, the Department of Commerce data. They regularly report for every industry what the historic cost and the replacement cost of the assets are. As a macroeconomist, I understand how they do that. They simply look at the investment in a given year, multiply that by the change of the Bureau of Labor Statistics measure of prices for specific assets of that type, and inflate it. And they subtract the part of it that's been depreciated. And they move forward to the next year and they do the same. So that's what my team in less than 2 weeks did to look at rail total replacement cost versus historic cost. So I wouldn't find it to be an impossible task. I would share Professor Kalt's notion that if you had a technical working group that could explain procedures such as I use, such as the Bureau of Labor Statistics and the Department of Commerce use, you could find a way to get a very good representation of replacement costs.
I would just add to that. From my experience, I'm actually personally involved right at the moment in a proceeding at the FERC in which generically, I can't talk about the confidentiality parts of it, but generically the same issue is being faced. Historic book accounting showing a pipeline earning more than adequate revenues, and yet the market demanding expansions of capacity. And recognition that some parties want it to be hard to give the regulator a reason to reject the use of replacement costs, because everyone recognizes here that it would change the nature of these revenue adequacy calculations in the direction that Dr. Brenner's data show. But through staff-to-staff discussions, again, not to criticize my colleagues that I work a lot with, but not disputatious lawyer to lawyer or expert witness to expert witness kind of discussions, but FERC has made very good use of technical working groups, staff to staff kind of conversations between interested parties. And I can't go into the details, but the finding of mechanisms using data of the type that Dr. Brenner has just mentioned are available. But I actually think that the challenge is one of finding a process that allows one to have a non-disputatious process to actually work on the problem, rather than a litigatory process that makes it so much harder.
I would just observe that what made it particularly nettlesome was it was like a summary judgment. We filed the petition to open up a proceeding, and rather than have a hearing, rather than open up a proceeding and allow some of the difficulties to be aired and perhaps worked out, the board, and none of you was there at the time, the board just basically said no. We're not even going to attempt to try to work our way through the challenges, and that was, I think, the most disappointing part of the decision.
I want to ask a follow-up question, because this replacement cost issue has been on my mind since I've been at the board, and perhaps I would have flunked both of your economics courses, because Dr. Galt, you said that no one questions the philosophy or the efficacy or the benefit of using replacement costs. It's just that it's too hard. But since I've been here and thought about it, I strongly question the logic of replacement cost when you're talking about something like a railroad, as I would if you were talking about a highway system. It's something that's been built over 200 years. I mean, I would question, could you even build it today? And if you built it today, how could you possibly charge a rate to the users of that system that would keep you internationally competitive? It would be absolutely impossible to do so. So if you start looking at the replacement cost, you've so driven up the total cost that you've just put it completely out of reason. And I'm struggling to see how that's a rational approach at all for the system that we're looking at. It might make a lot of sense in other businesses, and I can see that it makes sense in other businesses, but I don't see it in long-lived infrastructure that's been built literally over hundreds of years. And the only reason it's affordable today is because it's been built over hundreds of years.
Well, the service lives that I referred to for the Bureau of Economic Analysis aren't infinite, and they do say the service life extends to 54 years at the maximum. So we wouldn't be looking back.
Well,
at
what's
rights
that
of-
based
right.
on? A bridge is probably 100 years, the right-of-way is forever, the rail is a different life.
They have different service lives for different aspects. But in my testimony, I showed that there are countervailing effects. You were just referring to the fact that you would expand the denominator tremendously by looking at replacement cost. And I noted that you'd also expand the return, the numerator of a return on capital, because at the same time that you're making the base bigger by looking at the replacement cost, you're also counting as a return in the numerator the appreciation of the assets that remain because prices went up. And the difference, as I cite on page 15 of my testimony, is not huge, like I think you feared, but it's 2.5 to 3 percentage points.
So you're saying in the approach you would take, you would also take existing assets that may have been built 75 years ago, and you would appreciate them up to today's market value? Is that what you're saying?
Well, let's take a locomotive. What's a typical service life for a locomotive?
50 years.
25 years?
25 years. So let's say that you've got a locomotive that's 12 and a half years old. I would say when you bought it, it cost $1 million. Today's value of a full locomotive, if the inflation has doubled, right? It's doubled, but you've only got half of that locomotive because you've depreciated. But you would include in your income that appreciation of the remaining half of the locomotive that still has a service life. And that works to avoid what I think you feared, that you're expanding the denominator so much that it'll give you a trivial rate of return. I cited that the STB average of 7 Class 1 railroads is 9.6% 04 to 13, and if you do the full adjustments, you get, I'm sorry, I'm looking at the wrong exhibit, you get, the Bloomberg number is 7.2. So Bloomberg loses historic, if you use the replacement cost, you can get to a different number. So it's not, the numbers, the differences aren't huge. There's a direction of the bias that says you're suppressing the return, but the difference isn't huge because of the compensating adjustments you make.
Commissioner Miller, if I may, and I realize this may sound a little confrontational, but I'm actually kind of astonished by your observation, because if you believe that railroads can't charge prices that would allow them to sustain, replenish, and expand their networks, that's tantamount to saying they shouldn't be in this business.
Sustaining and replenishing is quite different from replacing.
Excuse me?
Sustaining and replenishing is different from replacing, and I would absolutely agree you have to be able to charge a rate of return so that you can fully maintain and sustain your network. But that's different than saying you're going to charge a rate of return that is big enough that you could fully replace your network. That's the question that I'm raising.
Sustaining means replacing over time. And if you look, I don't want to get too deep into economic modeling, but if you look at the assumptions that go into the board's discounted cash flow model that is used in SAC cases, which, by the way, one of the successes of the SAC process, we also know it's been very difficult. It has lots of challenges. Many of the problems with SAC have been overcome, including the agreement, universal agreement now, on a workable DCF model. If you look at the logic of that model, you'll see that it contemplates, it uses replacement costs, and it contemplates replacing them over time. And sustainability entails replacement over a long time frame.
Can I go back to
Sure.
asking some questions? Mr. Snipe, if there are two things I actually wanted you to comment on. One, and probably with the next panel who's going to be appearing. I think they'll be talking a lot about the competitive access feature of what the board had asked in the hearing announcement.
I bet
and
you're right.
One of the comments that you mentioned, or one of the things that you mentioned sort of just briefly, your view of what the board's authority is, and commented on mid-tech and the courts, the circuit court ruling. Could you just elaborate a bit on that? We had our hearing sometime, a year and a half ago, but just if you could just sort of re-comment on some of that.
Well, the specific point I was making that involved the reference to mid-tech is that back in mid-tech, the shippers, the complaining shipper party was making an argument that competitive access was, in effect, another way of getting at a reasonable rate. And the ICC and the court both held that access remedies are not a substitute for rate regulation. Access remedies, as approved by the ICC in the mid-1980s, were designed to address different kinds of competitive abuse from abuse of market power in pricing. So the notion underlying the access remedies that were adopted had to do with conduct type competitive abuses rather than pricing, and that's what I was alluding to. Mid-tech, I think, bought into that distinction.
Thank you. And then just one last question. At least I'll try to make up my last. Could you comment on, and I may butcher this a little bit, but Mr. Hennigan in the previous panel had mentioned, he talked about sort of the expectation of what revenue adequacy meant, and if that when it was achieved that it would mean, and again, I don't want to say this inaccurately, but something to the extent of differential pricing would no longer continue, or it would be limited or reduced. And he kind of, I think his view is that that's reality. That's exactly what it meant. Could you comment on what you believe the statute provides with and the history provides on from what the ICC said in coal rate guidelines, et cetera?
Well, that's a complicated question, and I don't want to go on and on. I probably could, but I don't think that would be wise of me. But let me just say, I don't start with the statute. I don't think there's anything in the statute you could find that amounts to an expectation that when railroads achieved revenue adequacy, differential pricing would somehow abate or become less differential, if you will. I just don't see anything in the statute. Now, obviously, we have coal rate guidelines, and we have that constraint in coal rate guidelines, which is obviously the major reason we're here. And we don't seem to know for sure what it means. The shippers take it as a given that it means when you become revenue adequate, the regulatory regime changes, and we say, I don't know how you get that. I mean, there is an inchoate revenue adequacy constraint, but it's not fleshed out, and nobody has come up with a meaningful explanation of how that could be implemented consistent with the sound economics that have governed the board's SAC regulation, rate regulation through SAC up to this point. And let me make another point about coal rate guidelines. You said two things this morning, I think, Vice Chairman Begeman, that were connected. And your point of departure was replacement costs, and you talked about the inconsistency of using replacement costs in SAC but depreciated book values for revenue adequacy. And then you talked about the disconnect between, I believe, the revenue adequacy notion and inability to use replacement costs. I think it's fair to say that coal rate guidelines builds in a kind of disconnect, but not literally. The disconnect is built in because we use replacement costs in SAC. The board uses depreciated original cost in revenue adequacy. And if you're trying to get at the same thing, i.e. a reasonable rate from two different perspectives, top down, bottom up, but you use two different standards for valuing assets, you're not going to get the same answer. And that doesn't make any sense to me. So I think there is kind of a historical anomaly in what guidelines says about revenue adequacy. And if you go back and read the decision, you don't find a lot of discussion about that disconnect between two different measures of cost. I don't think you find any discussion. So it hasn't been reconciled anywhere. We raised it in the Koch case. That's another one I lost. And my only solace is the guy who argued the case to the D.C. Circuit because the client was so tired of me was a fellow named John Roberts, and we lost there too. But the board carefully avoided engaging on the disconnect in the Koch case. And there were reasons why it could come out the way it did in that case, which I think is very instructive in terms of what we have in the rail sector. That was a pipeline case where the pipeline had set a system-wide rate increase across the board for all of its shippers. So a top-down approach fit, because we're talking about everybody, and we're talking about one rate increase to the entire pipeline rate structure. In the railroads, it's completely different. It is from the bottom up in the railroads. The rate structure consists of thousands of individual rates, many of them negotiated and inserted into contracts, all sorts of different rates on different traffic. There's no one-size-fits-all in terms of rate regulation. And so the reliance on the Koch case as a precedent for rail rate regulation based on revenue adequacy is simply unfounded. That was a long answer.
Thank you.
Just to follow up on that, I'm hearing clearly that the revenue adequacy constraint is number one. We don't have to do it. There's nothing in the statute that says we have to do it. Number two, I'm hearing from your economists and you that it doesn't make sense. It doesn't work. It makes no economic sense. So the third question is, this is a legal question more than an economic question, but can we do it legally? Is there a way legally that we can do it? Because we have this language in coal rate guidelines. Third Circuit was okay with it. So I'm just wondering what the railroad position is as far as can we do it?
I'll answer that two ways.
Sure.
We don't think you have the legal authority to do it, but I can understand why someone on the other side might say, we have a powerful precedent in guidelines and we have a good precedent in Koch. And I've just tried to explain to you why I don't think either of those precedents would hold up. So the second part of my answer is, as a tactical matter, might you get by with it if you tried to do it, I would say, you know, there's a chance we would go down with guns blazing. And why would you want to do that if you could find a way to make what everybody agrees, well, not everybody, not Professor Fallhaber and a few others, but what most people, including most on the shipper side, still agree is at least an economically valid framework for rate regulation using the standalone cost test. If we could find a way to make that easily administrable, you absolutely know that would pass muster with the courts because it's already passed muster, and it would be economically sound, and it wouldn't threaten upending the rail renaissance. Why wouldn't that be the way to go?
Maybe this is tangential to your question, Mr. Chairman, but I would also point to the fact that I believe the S-808, should it get enacted, would be the First Amendment to the revenue adequacy provision of your statute in 35 years. And that the report says that this section emphasizes clarifying standards and procedures for evaluating revenue adequacy, emphasizes the infrastructure needed in order for rail carriers to be able to meet the present and future demand for rail service. So it seems to me that the Senate and presumably the House and the President signs it, the policy is made clear that in taking a look at revenue adequacy, you have to take into account the ability to meet the future needs. And you were, I thought, on a very interesting line of questioning with the previous panel about the asymmetric risk that is there when a railroad would be faced with a decision to invest in a project above the cost of capital, would not be able to receive the benefit of that risk, but should the proponent, as the good professor here pointed out, be a little bit too optimistic and it comes in under the cost of capital, the railroad bears that risk but doesn't get the benefit if it exceeds the cost of capital. So if you combine all of that, it seems to me whether or not you have the legal authority, and as Sam said, we would dispute that. Congress has made it pretty clear where they would like to see you go.
So, Mr. Hamburger, can I ask a question? So is it AAR's position, is this a correct understanding, that revenue adequacy under the law doesn't in any way trigger any change in the regulatory framework? There's nothing inherent in the railroad's accomplishment of revenue adequacy that should accomplish or that should trigger a regulatory change?
Yes.
And then is it also AAR's position that if we calculate revenue adequacy, we should do that based on replacement costs?
Yes.
And why does that matter to use a complicated, difficult process to calculate revenue adequacy if, in your view, revenue adequacy has basically no meaning under the regulatory framework?
May I address that at the risk of
please go ahead.
Incurring Mr. Hamburger's displeasure? You know, he rehired me once when I lost.
You can go to lunch with me then.
I'm picking fights with everybody this morning. It seems. It's not my nature. I think that if you were to agree with us that revenue adequacy doesn't trigger a different regulatory regime, then frankly we wouldn't care very much about replacement costs, because it's like, are you measuring it in centimeters or inches, right? It goes back to my response to Vice Chairman Begeman's question, what is this annual revenue adequacy inquiry about? It's about measuring. Are they making progress? How, what's the slope of the line look like in terms of progress? If you measure progress, if you're not going to do anything with that measurement other than to say things are working under our overall regulatory regime the way Congress had hoped, that's a pretty good thing. We should be happy about that. If you're going to do that and you're not going to implement rate regulation based on the magnitude of your cost of capital determination, then I don't think we really would need to change to replacement costs. I think we have made the argument in recognition that something could happen down the road this very hearing. So in 2008, we weren't revenue adequate, but we said, you know, let's take a shot at replacement costs because the day may come when some subsequent board says we want to regulate on the basis of revenue adequacy. We ought to put ourselves in a better position if that ever comes to pass. Now the question is on the table. And others aligned with me on the railroad side might not give you an identical answer. I'm not purporting to speak for everybody, but that's my answer to your question.
You know, I don't, because, you know, as you know, I've been here for about 15 months, so maybe if I'd been a long-time practitioner, you know, I'd have a different view. But, you know, what it seems like, based on my understanding of the way the concept and the importance of revenue adequacy had been explained to me as I was coming onto the board, that AAR has changed their position or is much more forcefully advocating a position that revenue adequacy doesn't basically have meaning. And maybe that's, I mean, honestly, maybe that's always been your position. Maybe that's been clearly and publicly stated. But up until the Staggers hearing before the TNI subcommittee, it's the first time I heard anyone say revenue, it doesn't matter if they're revenue adequate. That shouldn't have an impact. And so I'm curious if this is in fact a change in position as the railroads have gotten closer to what some might consider revenue adequacy, or am I just misunderstanding and that's always been the viewpoint?
I don't think it's a change in position. I think what you've seen and heard is that the issue has come into focus in a pretty concrete way via this proceeding. And in the past, we speculated, could something happen in the future? But there was never, to use a legal term, the issue wasn't ripe, except in the Koch case, which AAR was not a party to that. Those were private parties. The issue was somewhat teed up there. But other than that, the issue has never been teed up. I mean, when you introduced this proceeding, when Chairman Elliott started this proceeding, it focused our attention, very acutely on the issue.
I think that's right. I think if there are some colleagues who were around when the guideline case came down, I think there was probably some theoretical consternation at the time, but it was theoretical, and I think it has become ripe as the industry is finally beginning to achieve some good sustained financial health. And so I wouldn't characterize it as a change in policy, but perhaps more a change in having to address it, partially because of this proceeding.
So in your testimony today, really, and in many ways, all four of you have used pretty strong rhetoric. Price caps, unable to accomplish the national goals for transportation, those kind of things. As the WCTL laid out their proposal, they use language like, a narrow scope to this remedy, an approach that really applies to a small sliver of the railroad traffic. And I'm wondering if you could talk a bit about why you look at a proposal like that but think that it could have system-wide implications for the ability of the railroads to continue to operate.
I think Joe Kalt should speak to that under the rubric of the duck.
Well, I will say, your question, before you asked it, I was thinking the same thing. I realize there is a difference in tone. I think it's because, in the less strongly worded part of what I had to say, you heard me talk about so-called old-style public utility regulation or earnings-based regulation. And I think that, independent of whether this is right for the AAR or not, when I talk to other transportation and other regulatory economists, it is kind of striking that the board is considering or is being, very serious proposals being made to undertake some form of return to earnings-based regulation, one way or another, looking at aggregate company-wide revenues relative to some measure of cost of capital, some measure of the cost of capital. And as I said in what I said here, and I think I said it in my written statement as well, all over the world, policymakers, left, right, conservative, liberal, free marketeers, people in still non-capitalist countries have been abandoning earnings-based regulation because of three things, I think. I'm trying to summarize a lot of research on everything from electric power to railroads to pipelines to telephones and everything else. What's really behind it? Number one is that, and Dr. Brenner touched on it, you introduce severe distortions. It's not just like, they're little minor things. When you engage in earnings-based regulation, if there's an opportunity to engage in padding of your costs, there's actually a word in famous research known as the average Johnson effect. If you've got an opportunity to pad your costs, because if you don't pad your costs, you're going to be found to be revenue super adequate, and something's going to get rolled back somewhere, some way, a rate or revenue is going to get rolled back. Then we found throughout the United States, elsewhere, people padded their costs, not because they were evil or anything else, but because they were being rational, responding to the capital markets, or, as Dr. Brenner suggests, you're less diligent in taking care of costs. And so you end up with famous cases that were used in the electric sector, for example. San Onofre nuclear power plant, they just forgot to read the architectural plans and installed the retaining walls backwards to the tune of a $5 billion error. Why? Because the pressure to hold your costs down gets reduced. There's a sense in these proceedings that, if we went to something different, it'd be easier. What it does, and it's the second reason that we got so concerned about this regulation, you end up having to have prudence decisions because they're not going to say they padded their costs. You're going to have a prudence hearing, and you'll have different kinds of experts and probably different lawyers in front of you fighting over these things of whether the investments make sense, whether the revenues, commissioners, members of the board, the revenues are too high because they've been inefficient in building their system. Well, that leads to a whole other kind of layer of regulation. And then lastly, this point, I know it's easy for it to sound like waving the stagger's flag, is what we transportation economists sometimes call it in our seminars. This has been a tremendous success. Everyone recognizes that. But there is that danger. And these analogs I draw to things like long live rental apartments in New York City or something, they're real because we have gone through cycles of this where the system gets frustrated, entices the capital in. It takes a long time beyond our cycles as industry people, as experts, researchers, as lawyers, as you as regulators. The really bad consequences are going to have to happen after all of us are not here anymore. I've always viewed this is me talking, I can't speak for the AAR. I've always viewed the revenue adequacy recognition of that as a problem. I was a young economist, but still involved to some extent. During the late 1970s, we had the big sitting duck problem. We had killed the duck through decades of regulation untethered from sound economic principles of competitive pricing, protecting the customers against abuses of monopoly and so forth. And quite reasonably, you would have a system that would say to the policymakers, to yourselves, to the regulators, let's not do that again. We'd like you to not adopt policies
So,
that force you down that path.
Dr.
So-
Cole, can I ask you a question, though? I mean, I grasp what you're saying, and I certainly appreciate the concern of that approach and would understand that generally people are moving away from it. And if this was a proposal that said that once railroads were revenue adequate, they couldn't raise rates beyond inflation across the board, I think all of those things you've said would end up happening, and it would be disastrous. What I'm trying to understand, taking in the totality of your testimony, if we're talking about this thin slice of the pie of railroad traffic, which is truly captive and that is subject to STB regulation, and if you apply this sort of an approach to it, do you see that having some ripple effect? I mean, is there some economic reason to think that that remedy to a very small portion of the traffic could have the kinds of consequential impacts that you're talking about?
I guess I'll defer to Joe in a second, but I'd like to just challenge the basic foundation that it is a very narrow approach. If you add the 14% and the 5%, you're at 19%, and that's of car loadings. I think if you take a look at it, I'd be willing to bet because of Ramsey pricing and differential pricing and elasticity of demand that 19% of car loadings might be a little bit higher in terms of revenue. So even if it is, it's one. Even if you say it's equal, 1/5 of the revenue then would be capped. And so I don't consider that to be a narrow approach. And that is one proposal. I believe another proposal that has been made is that there would be a rebate to the captive shippers from the excess profits that received from the competitive traffic. So that then goes much beyond a narrow approach. And so, depending where all of this comes out, we're not talking about just a sliver of traffic or a sliver of revenue. So I think that is what is driving our perceived and as you perceive it, a major concern.
And I would just say I think your basic intuition is right. The primary area of distortion would be where you create distorted incentives in the, let's say, 20% of car loadings, whatever it is. But the other thing we worry about is, this is a network industry. And so if you're having distorted decisions being made in this section of track, in this form of IT, whatever it might be, you're potentially affecting, hence distorting the pricing, the supply availability in other sectors. And so it's not just allocation of railroad resources, but allocation of our freight transportation resources more generally. And so there you would expect some spillover effect, if you will, because it's a network industry and like a really important railroad network industry.
And I'm wondering, too, if either of the economists, if you could address this question. One of the things I've, tried to understand in my own mind is, in this industry, we talk about, setting market rates and the power of a market set rate, which makes a great deal of sense to me. But when you're looking at captive shippers, truly captive shippers, and there are those out there, in fact, is it possible to set a market rate because there is no market? Or that's what I would conclude. And I always thought that's the basis for the sliver of regulation that continues to exist in this country around railroads, because there's a recognition that for some traffic there simply isn't really a market component to allow a rate to be set. But is that a misunderstanding on my part of what it means to set market rates?
No, I think in some sense you're right. That is, we would say in certain situations there may be no competitive market. There may be true market dominance going on. They never like me to say that, but it's true. That's why you have your proceedings, right? Consequently, what you've done, what the board has done with the SAC test framework is essentially run a hypothetical. It's running the hypothetical of, okay, we don't have a market. There are barriers to entry in certain places. But what if there weren't? How would that operate? And I know it seems like just a teaching example, but it's actually a lot of research about these kinds of things. Think of my apartment house. If I'm an apartment house owner in Washington, D.C., I've got a fully depreciated building, The rates, I'm in a very competitive market. There are 1,000 of these things around. The market will set my rate, because it's a healthy and growing market, will set my rate sufficient to draw in capital of equivalent quality from new entrants. And that's actually what your SAC test framework is doing. It's creating a market. It's a hypothetical construct. And many of the difficulties arise because it's hypothetical, meaning I know that we should have concerns about how difficult it can be to implement, how detailed it gets and so forth, and is it usefully detailed. But that's what you're doing. You're actually saying what you're saying. There's not a competitive market. We'll create a hypothetical market where it's just basically, by the way, it's antitrust economics. It's just antitrust economics in a market with free entry. No one can exercise market power. Its prices are going to be set by what the entrant is holding them at. And so it's just basic we dress it up as contestable markets, but it's basically antitrust economics.
I think, in such proceedings, you're not devoid of market information. You can refer to what's the market cost of labor to run this railroad. You can refer to what's the market cost of tracks, of locomotives, of all that. And then adding on a reasonable return, you can say, what is the price? And there is no market price that is a competitive market, but what's the price that would have been produced in a competitive market with those market-based costs? So you do have a lot of market information. The only competitive market piece you don't have is the price, and you use your calculator to come up with that after you feed in everything else.
So, I'm sorry, I know this is getting a little bit long, but as we have two economists here, I'm interested in going back to an earlier question that Dan asked, and that was about the TRB study. Have either of you seen or heard of the recommendations?
Yes.
And what I thought was interesting about the approach they were recommending as an alternative to SAC was that what you would instead do is you would, as I understand it, look where you have competitive rates, create a model that could then forecast what a competitive rate would be even where you don't have them, and then use that as a way to compare a rate to say, is this an appropriate market rate? And I'm wondering what your assessment is of that sort of an approach.
In some ways, it's interesting. What you just asked is very closely related to your prior question about the absence of a competitive market. I think as colleagues and I have talked about it, of course, it's in theory, or as a starting point, it's not a crazy thing to think that, well, let's go look at the price of tomatoes over there and see what the price of tomatoes ought to be here. But as colleagues and I have talked about it, the kind of thing we're worried, we concern ourselves, although it would probably increase the demand for economists pretty considerably, rather than those engineering types who do the SAC stuff, it'd be more the economists. Here's the thing that we worry about. We tend to have captive customers, problems of market dominance, where the classic thing that you always get spit back at you by economists, economies of scale and scope are such that the market doesn't support multiple railroads, for example. And in that situation, then what that actually means is, some other place where I see some multiple railroads competing, well, that's actually not a comparable to where I need to set the rate now. Or where I see railroads competing with trucks, but if that it's probably not going to be a comparable, because if you're competing with trucks, you wouldn't be market dominant. And so the problem, in other words, arises because it's not anybody's fault in some sense. The technology of economies of scope and scale mean that those pockets where you're concerned about market dominance aren't going to have ready comparables. And we've actually, some colleagues and I have been talking, it probably devolved back into, well, I know how to create a comparable. Let's think of a free entrant, and we're back in a SAC world. In other words, you sort of find yourself going back to, I'll have to adjust apparent comparables for the costs of entry where these economies of scale and scope make this situation not comparable to any readily observable actual market.
Although, I mean, in the TRB study, it seems like they allowed for that because that's just the way you kind of get in the door. And then once in the door, both parties have the opportunity to make their arguments either about why the rate's too high and doesn't make sense, or why this is an appropriate rate for this particular.
Yeah, but
it seems like it gives you the opportunity to both create the threshold of who gets looked at, but then once looked at, you can bring in the qualitative reasons why a rate might need to be higher and why that's justified.
I think what I'm trying to convey, I guess, is the more I've thought about it, at least some of my colleagues, bringing those other things into the room wouldn't just be qualitative. You'd start to be talking about the economies of scope and scale of this service, and you're immediately back into a SAC world. In other words, you'd be arguing, I'm not comparable because my costs are so different, because I'm in this kind of network rather than the one you have used as your comparables test. So the adjustment for comparability that the TRB talks about, I think the logic of our profession leads you very quickly back to worrying about, are there economies of scope and scale, particular, that are non-comparable in this service compared to whatever might be offered as a comparable? So that's the logic of where the letting additional arguments in takes you. Damn, we're right back into SAC. Pardon my English.
One other question regarding replacement costs, and this just kind of hit me while we were discussing it. Has the concept of replacement cost in our revenue adequacy area ever been challenged in the courts, versus historical costs? Was the 2008 case taken up? I just don't know. Or have the revenue adequacy decisions that we put out every year ever been taken up?
There certainly has not been a direct court challenge focused on the use or denial of use of replacement costs that I'm aware of. I can't tell you for sure whether any of the ICC's revenue adequacy decisions that were reviewed on appeal may have tangentially raised those issues. We can take a look at that and answer the question, but I don't think there is a rich case law in that vein.
We did not challenge the denial.
Oh, no, I'm sorry. No, there would, yeah, no case.
No, I think I'll just close by saying I didn't sit down here at 9:30 thinking I was going to talk about replacement costs, and it just kind of came about. But it really, for me, it's not that I'm the champion, and for all of you folks in the room who are all nervous, I'm not the champion of using replacement costs, but I'm bothered by the disconnect. I'm also bothered every time I hear Mr. Colt mention SAC. I realize that many consider it the gold standard. I also have seen it in practice, and I know that not only do shippers have a frustration, I think board members and even board staff have a frustration, and the fact that it has turned into such an enormous undertaking, the cost, the time, the expense. Cases started before I got here that won't end before I leave. That, I'm not good with that, and so I will continue to sort of as Deb had mentioned, that she is hoping that, or she is seeing a lot of things connected as far as different proceedings. Well, I don't see them fully connected. I certainly do see them. I'm still incentivized that I want a process for really small shippers that is meaningful and fair, not tipping a scale, but I'll just leave it at that.
I guess, also on that note, you've really focused a lot on the SAC case, Mr. Colt, and in that TRB report, they were pretty hard on it as far as the IRCs and some other economic theories. And I'm not going to ever debate economics with you because I don't think I do very well. But I assume the gentlemen that came up with these ideas are your colleagues, the kind of people that you would debate these kind of issues with. And I'd just be curious to hear your thoughts on their criticisms of the SAC test.
Well, I think they're very similar. When I read it, actually, and talk to some of the people, they're very similar to what was just raised. That is that the kinds of inputs, the kind of processes, the kind of modeling and so forth are proving to be extremely expensive, extremely contentious. detailed beyond kind of all comprehension sometimes. You know, should we have one more crewman on the 20-mile move from Toledo to, you know, as a regulatory economist, we should always be looking for ways, and I know this board has taken up issues of simplifying SAC and so forth. What I come away with from all of that is look, no one's going to honestly reject the idea that a free entry market will be competitive and those competitive prices are the right ones. But how do you get to them? I would say at this point that and I talked a little bit about like these FERC technical working groups that have been used rather than a rulemaking and so forth. Maybe things the researcher in me says, maybe we should be doing some serious research in a non-disputational way, non-litigatory way, in looking at that challenge of, okay, if ERCS is not working, or what's an alternative? Or, you know, on any of these components. As Mr. Sipe mentioned, you know, things like finally reaching agreement on the DCF approach in SAC is like a big deal. These things evolve, but it takes, you know, leadership. It also takes some cool heads to focus on these in a systematic way to see how to improve a process. And so I keep thinking this is right at the moment in the history of this industry is a process problem. That is, how do we come to a better way of implementing both ideas like replacement cost and a SAC test.
I think we're done. Thank you very much. I really appreciate your answers and your testimony.
Thank you very much.
Very helpful.
Thank you very much.
Why don't we have the next panel come up so we can just get situated? Are you okay?
Yes, indeed. Thank you. Good idea.
Okay, why don't we get started with panel number 3.
Good afternoon, and thank you for letting us get situated. I'm Karen Booth. I'm a partner at the law firm of Thompson Hine, and I'm general counsel to the National Industrial Transportation League. It is my pleasure to appear before the board today to address the important policy issues involving revenue adequacy. With me is Mr. Eddie Johnson III from the Chemours Company, which is a successor company to the performance chemicals business of DuPont. Mr. Johnson and I will split the 15 minutes allocated to NITLIG this morning or this afternoon, and will be very pleased to answer your questions at the conclusion of our testimony. The League's testimony will focus on a single issue raised by the board in its notice of hearing. That issue is whether a railroad's revenue adequacy status should impact the availability of competitive access remedies, including the League's competitive switching proposal, which is the subject of the board's Ex parte 711 proceeding. We will address this issue based on the board's governing statute, important policy considerations, and in light of recent service issues faced by the industry as you requested. So beginning with the governing statute, it is clear that neither Staggers or the reforms subsequently adopted in the ICC Termination Act directly link competitive switching remedies to a carrier's overall financial status. These concepts appear in completely different sections of the statute, and there's no direct reference or even an inference that connects the two. Mary, would you mind? I did bring with me just a few slides. Whoops, you can see it here. So just by way of example, and really for the record, because we don't have a lot of time, this is the reciprocal switching statute. And as you can see, it's just a broad public interest standard, or one in which it would, where switching would be practicable or in the public interest, or what's underlined here, where such agreements are necessary to provide competitive rail service. So at least in the switching statute itself, there's no direct link to revenue adequacy. In contrast, other provisions of the statute, such as the National Rail Transportation Policy, directly link revenue adequacy to rate reasonableness determinations, demonstrating that Congress has made those connections where they are intended. Next slide, Mary. So here you have one of the transportation policies where we see this to be the case. And again, just underlined kind of the relevant language here, indicating that to maintain reasonable rates where there's an absence of effective competition, and most importantly, where rail rates provide revenues which exceed the amount necessary to maintain the rail system and attract capital. Additionally, the statutory provision directing the board to establish standards and procedures for determining railroad revenue adequacy has no relationship to competitive access. Next slide. I'm not going to read this. This is really just for the record, but a lot of text there, but again, no connection between the two. Going beyond the clear text of the statute, there's no legislative history that otherwise shows Congress intended to restrict the board from authorizing competitive switching if the defendant railroad's overall financial status was determined to be revenue inadequate. Now, what I'd like to do next is just turn to the last slide, Mary. And it basically touches on not just the statute, but the board's current competitive access rules. I'm sorry, what happened? Oh, okay. Well, this next slide, which you can't see, and it'll be submitted in the record, is a provision from the board's current rules. And it's the rule that deals with prescription of switching arrangements as well as through routes. And that specific rule that exists today has express language which basically prevents the board from considering revenue adequacy. It basically states here that the overall revenue inadequacy of the defendant railroad will not be a basis for the denying prescription of reciprocal switching. Thus, as a legal matter, there's no statutory provision that requires the board to link competitive switching and railroad revenue adequacy. And in fact, the board's current rules expressly prohibit the agency from denying a switching remedy even if the defendant carrier is revenue inadequate. So there you go. Thanks. So despite the fact that there's no statutory linkage, as a policy matter, the NIT League believes that the board should not condition a switching remedy based on the revenue adequacy status of the carrier. And that's because when evaluating whether to grant a competitive switching remedy, the League believes that the board should focus on the characteristics of the rail movement at issue, and particularly its captive status, rather than the overall financial status of the defendant carrier. This is precisely the approach followed by the League in its competitive switching proposal, filed with the Board 4 years ago and currently under consideration. The League CSP already limits a captive shipper's ability to obtain competitive switching by requiring that shipper to meet certain conditions. Specifically, under the CSP, a shipper that can show that its rail movement is captive and subject to monopoly power, is charged rates well above competitive traffic, and is located near a working interchange may be eligible to obtain a competitive switching remedy, even if the defendant carrier has been found to be revenue inadequate. Similarly, a shipper that cannot demonstrate an improper exercise of market power by its rail carrier may not obtain a switching remedy under the CSP, even if the serving carrier is deemed to be revenue adequate. Accordingly, the League CSP is narrowly tailored to address an unreasonable assertion of market power over a specific rail movement, and the overall financial status of the defendant carrier should not stop the Board from solving the problem by introducing a competitive alternative as contemplated under the switching statute. Moreover, the League CSP would provide captive shippers in the Board with an alternative remedy to a rate case. This remedy would be entirely consistent with the National Rail Transportation Policy published at 49 U.S.C. 10101.1, which is to allow them, to the maximum extent possible, competition in the demand for rail services to establish reasonable rates for transportation by rail. Nevertheless, in evaluating whether to move forward with the League CSP, the Board should not ignore the fact that 3 of the nation's big 4 rail carriers have been revenue adequate under the Board's own high standards for measuring that tool. And that's been the case for the past 3 years. Based on other financial performance measures, all of the major railroads are financially strong and continuing to grow stronger. The current financial strength of the rail industry should give this Board greater comfort that adoption of the CSP will not harm this industry, financially, and we will be addressing also operationally. The League has already demonstrated in the 7-11 proceeding that the CSP would potentially result in only a very modest increase in switching arrangements. Only 4.6% of carloads would be impacted, and I think it's very important to note that that was really all eligible traffic, and as we, I think argued ad nauseum in 7-11, not all of those carloads would even be switched. The League has also demonstrated in 7-11 that the CSP would have a very small impact on railroad revenue. Only 2.6%, again, of the big 4 railroads' gross revenue would be impacted under that proposal. The railroad's achievement of revenue adequacy, or for those carriers that haven't gotten there yet, still recognizing their very strong financial condition, along with the CSP's modest impacts on rail traffic and revenue, demonstrate that the railroad investment would not be unreasonably curtailed if the CSP were to be adopted. We believe competition will spur investment. Thus, the League respectfully urges the Board to move forward with the rulemaking on the CSP. We would also like to make a comment on the recently released study by the Transportation Research Board, already brought up here today. The League believes that overall, the TRB researchers did an excellent job fulfilling the congressional mandate to DOT to provide the study on the economic regulation of the U.S. freight railroad industry. The study includes a number of very interesting recommendations to help modernize rail regulation, of which the League is still reviewing. However, the League would like to address one specific statement included in the report, which followed a discussion of the League CSP and which offered a suggestion for implementing competitive switching today, presumably under the current regulatory system. Specifically, on page 112 of the report, I'm not sure we're going to get our slide here, but I did want to put this language up so everybody could see it. This is what the suggestion was by the TRB. And you'll see here that it recommends as a starting point for STB to consider reciprocal switching, it could be used as an optional remedy for rates that have already been ruled unreasonable and thereby offer an alternative to a prescribed rate. This statement seems to suggest that today competitive switching should be implemented by the board only in the context of an unreasonable rate dispute, only as an optional remedy to rate prescriptions, and only after a rate has already been found to be unreasonable. Our understanding of the TRB suggestion is that the shipper would be required to first prove market dominance and litigate and win a SAC case before a switching remedy would even be available. This approach would make the regulatory process even longer, more complex, more expensive than it is today, and would only discourage shippers from even attempting to secure competition through switching. This approach would have the opposite effect of the League CSP, which is designed to provide a more simplistic and cost-effective approach to implementing the switching statute. Accordingly, the League opposes implementation of competitive switching as an optional rate case remedy as suggested here on page 112. I would like to conclude by briefly addressing the board's inquiry regarding the impact of recent rail service problems and the League CSP. First, the potential for the CSP itself to create additional service problems has been vastly overstated by the railroads. The railroad service concerns are premised on an incomplete study of the CSP that lacks credibility for many of the reasons that were already discussed in that proceeding and at the prior hearing. Second, the CSP itself would provide this board with the power to deny a request for competitive switching under the CSP if the defendant railroad shows that the switch would be infeasible, unsafe, or would harm rail service. This built-in protection directly addresses any service-related concerns and would prevent them from ever even occurring. Third, the board should also consider that competitive switching in some cases can actually operate as a solution to service problems by providing an alternative route if the incumbent carrier is experiencing congestion or is otherwise unable to meet the service needs of the shipper. That concludes my testimony, and I'd like to turn the floor over to Mr. Johnson, and I'd be happy to answer questions at the end. Thank you.
Good afternoon. I'm Eddie Johnston, Manager for Sustainability and Government Affairs with the Chemours Company. Thank you for holding this hearing on revenue adequacy and its impact on rate regulation, as well as on competitive access remedies and rail service. Chemours is a publicly traded company that is a spinoff of the performance chemicals business that was previously part of E.I. DuPont de Nemours and Company. Chemours is a very substantial user of rail services in the United States, and in its former corporate organization within DuPont has been a frequent participant in proceedings before the board. More than 75% of Chemours facilities are captive to a single railroad. Contrary to Mr. Hamburger's impassioned testimony, we do not generally face a competitive rail industry. My company does not see or experience competitive pricing or service behavior from our rail service providers. Chemours is a member of the National Industrial Transportation League, and my testimony is being provided as a League member. On behalf of the League, I will address the board's question regarding the impact of rail service issues on the League's request for the board to increase competitive switching between rail carriers. As you know, in July 2011, the League filed a petition asking this board to open a rulemaking to revise the existing competitive access rules, and specifically to permit competitive switching between rail carriers for captive rail movements that meet certain qualifications. The nation's rail carriers have opposed the League's competitive switching proposal, claiming that the proposal would adversely impact rail service. Chemours believes that the League's CSP would not degrade service, but instead would offer routing alternatives that would help improve rail service. Indeed, switching arrangements under the CSP might lead to better service in situations where the incumbent's line is experiencing congestion or its route is more circuitous or less efficient. Switching arrangements occur every day during normal railroad operations. Carriers routinely work together in yards and in locations where more than one carrier has access to the tracks. We believe that rail carriers would be able to effectively cooperate and manage an increase in switching services that could occur under the CSP. Our own experience demonstrates that competitive switching does not degrade service, but can improve service while providing solutions when a carrier is not able to meet a shipper's needs. Chemours currently has 4 facilities in Louisville, Kentucky, Pascagoula, Mississippi, Beaumont, Texas, and Strang, Texas, that are open to reciprocal switching. Rail service to and from these facilities is at least equal to the rail service at our many captive plants. The availability of a second carrier provides an alternative that can be used to address service deficiencies or disruptions. Our use of the switching options at each location varies and is based on factors including price, service, and routing efficiencies. To better meet our service and delivery needs, we prefer to use the alternative carrier for a substantial portion of our traffic at 2 of these 4 locations. At the other locations, we use the switching arrangement only for a minority of our traffic. Also, at one of these locations, we prefer to use a 3-carrier route instead of a 2-carrier route to a particular destination due to superior service and favorable economics. My ability to choose an alternative routing has helped Chemours better meet the needs of valued customers. Moreover, we see no difference in the carrier's investment at our captive plants versus our competitive plants. Chemours also has 2 facilities in New Jersey that are effectively dual-served as part of the Conrail Shared Assets area. There is an ongoing coordination between the rail carriers at the yards in those areas. In our experience, service at these 2 facilities is generally better than at our captive locations. Accordingly, we believe the nation's rail carriers are experienced and well-equipped to handle additional switching arrangements and changing traffic volumes that may arise under the CSP. Let me close with one more thought for your consideration. A career in business has taught me that service can only be assessed from the perspective of the customer. Yet the board and rail carriers seem to define rail service very narrowly as transit time and system fluidity, both internal railroad measures. To rail customers like me, rail service means much more. Service includes safety and accident performance. It includes predictability of deliveries. Service involves responsiveness to my business needs, including how well and how promptly my suppliers respond to concerns, problems, and changing business conditions. And finally, a mark of exceptional customer service, perhaps the mark of exceptional customer service, is simply how easy it is for me to do business with you. Aren't these the very ways you and I evaluate customer service as consumers? I think so. Should we expect less from the nation's railroads? I have observed that excellent customer service thrives in a vigorously competitive environment. It falters when competition is lacking. The League's competitive switching proposal would help introduce more rail-to-rail competition where it is needed most. It would give me and other captive shippers a service choice, just as we have with other suppliers. I therefore respectfully ask this board to move forward with a rulemaking on the League's competitive switching proposal. Thank you very much.
So, Karen, you were pretty clear, but I want to go back. The Knit League's position is that we shouldn't tie the concept of revenue adequacy and competitive switching together, correct?
That's correct. We don't see any intent for that in the statute.
Yeah.
Deb is right. Your testimony was very clear, actually, both of you. We appreciate that. Mr. Johnston, it was really helpful for you to kind of walk through the 4 plants that you have the ability to have competitive access to, and then the 2 with the Conrail, the shared asset areas. So how many, so 6 plants out of how many?
Roughly 26.
Out of 26.
Yes.
And could you just, and I know we in the previous hearing and proceed, if this is a repetitive question, I don't think that it is, but I know you've appeared here for a few times before us on different matters, but how often do you sort of explained it as far as that you don't actually switch a lot, or you, it's there if you need it, but just in practical terms, like how often do you switch to another carrier, and how quickly do you make that decision? I'm just, we've spent the last year and a half, or not the last year and a half, but the previous year with the service issues that were going on were of really great serious concern to me and to the board members, and I'm just trying to understand from a firsthand perspective of how you have gone about your use of competitive access.
Yeah. So of the 4 sites that I described, they range from the use of the alternative more than 95% of the time at one of the sites to less than 5% of the time at one of the other 4. And the other 2 fall in between, obviously. So its use, its use varies widely based on service performance, based on
But I mean, does it switch within? Does it
economics.
change? Could it change on a dime, like in a week, or is it changes in a month, or it changes in how often, or all of that?
So if there's a service disruption for any of a variety of reasons, we have the alternatives to switch the traffic onto another carrier. Obviously, that has to be worked out with the carrier in terms of how quickly that can be done. But it's managed and it's done efficiently in these cases. Again, railroads pass traffic back and forth every day. Mm-hmm. This is simply another instance of their doing that. Is that responsive to your question?
Has it affected your rate? I mean, as a consequence in those facilities where you have competitive shipping, do you think you've got a more competitive rate?
In some cases, we have better rates, yes.
Just one question. It probably goes back to a question I've already addressed, but in the reciprocal switching provision itself, it requires, once reciprocal switching is put in place, that the 2 railroads meet. How do you see that working, having the 2 railroads? And obviously, if they don't reach an agreement, then they have to come to us. But does that make you nervous at all that puts you in that position?
Well, as you know, the statute has that requirement. The railroads certainly in the first instance are to come to their own agreement on what the switch fee should be in a given situation. If they can't agree, then of course either one of them or a shipper could come to the board. But look, our view is that introducing competitive switching is not likely to be introduced in every possible scenario, and there may be instances, there are lots of shippers who worry about whether or not railroads will aggressively compete So there is some concern related to the switch fee, but I think from NITLEAG's perspective, we believe that it will work, it'll get started, folks will get comfortable with it, and there'll be a process for it. And it may be that there are pockets where the competition isn't vigorous enough. And it may be, and we hope and we believe, that there'll be many other locations where it would work.
Thank you.
So I'm not a lawyer
Go ahead.
or an economist. I'm just a businessman. And so I tend to think in just common sense, kind of everyday terms. And so to me, it's a question of having a choice versus not having a choice. And more times than not, it's better to have a choice and be able to exercise that choice, whether I actually exercise it or not, than it is not to have the choice at all. And so just from a common sense sort of perspective, to me, that's what this is about. And as I say, at 20 of the 26 plants, I have no choice. I have no choice whatsoever. And so if I could pick up a choice at even a couple of those that I might at some time be able to take advantage of for the benefit of my customers who I serve, that's a good thing.
Thank you very much. We really appreciate you coming here today.
You're welcome.
Especially someone that's not an economist or a lawyer. I appreciate that. As I said earlier, we are going to take a 30-minute break. So why don't we get back here around 1:45, and we will proceed with panel number 4. Thank you.